Your Honor, Larry Tipton for Mr. Walsh.
Good morning. We'll wait for Mr. Walsh, but while we're waiting, I'm just going to pass you out a couple of versions of something I want you to look at. I have a preference. I don't know how many copies that is, but I think it might be enough. We need more. I have more. I just put that to the side, counsel, until we get there.
Thank you.
All right. Good morning, Mr. Walsh. I said good morning to everybody else, so good morning to you too. So since the version that I sent you at 1:55 p.m., I've made the following edits, either based on prompting by you or by my own accord. So on page 9, the use of a dangerous weapon is out. On page 17, the stipulation, separate instruction, I incorporated that into the evidence instruction. On page, it was on page 19. So what I did is I just added into page 19 some text. It's the second sentence. The evidence consists of the testimony of the witnesses, as you recall it. And then I just added in there the things that were marked as exhibits and the stipulation/agreements of the parties, rather than have it as a separate to-do. Just making it a little bit more streamlined. I edited out the last sentence of graphic photos instruction on page, I think it goes to the top of whole page 18 as irrelevant to this case. And I also have removed the separate section later on page 18 about opinion testimony as repetitive of the expert testimony section above. On page old page. Now I can't find it right away. You may know where it is when you read through it. It says you'll have all the evidence with you. And I removed the non-relevant weapon and put in including the tools. But as I was thinking about that last night, the mental note was, what does the Commonwealth, or how does the Commonwealth intend to safely put those tools? So what I've done in other places, or what I've seen done in other places, and it most often comes up in the context of a knife going back. I've seen other DA's offices basically take the knife and it's like they put it on a hard board and then they strap it down. So the jury can see the item but can't hurt themselves unwittingly with the item. It seems that the same could be done of the tools in this case, if you have the capability to do that. I think I've seen that done in Middlesex, Plymouth. That's how they sort of handle the issue. How are you planning on handling it?
We're working on this one.
Okay. So what I have in my mind, just so that, and I think law enforcement in the past has done it for the DA's office. So they may have the strapping mechanisms, but as long as I'm assured that they can go in safely to the jury deliberation room, either with a sheath cover on it or preferably strapped down to a hard board, it seems to me that that would be a good approach. Anybody object to that?
No, Your Honor. We'll work with defense counsel, but we're trying to get some supplies to do that this morning.
All right. So I passed out to you two versions. I went back to look at different instructions I have. I looked at a few different things, and this relates to the direct and indirect evidence instruction. And the version 1 is what I will call I put this in air quotes, I'll call it the Superior Court version of or what I most often see in the Superior Court, which is different than the District Court version, which is a little clunkier, I think. But anyway, you always like what you like, right? That is probably the more traditional, old-fashioned perhaps. As I read through it last night, I think it reads better than the version that I put into the first draft, but I don't have strong feelings about it. So if we have agreement between the parties as to which one you like better, I'm happy to read that. I think both of them are accurate representations of the law. I have a preference for version 1. take a look at that and let me know when you've finished looking at them and have an opinion.
Your Honor, the Commonwealth doesn't take a position. Neither one seems
Fine.
comfortable.
Normally, honestly, I don't spend a lot of time on this in most cases but this case is one that I spend a little more time on it. Yes, Attorney Porges.
Your Honor, we're requesting version 2. So if no one else has a position, I ask the court to read that.
All right, which is my version 1, I guess, right? It's the version that was in the instructions yesterday.
I believe so.
Both are correct recitations of the law, so if you wish to draw from any of them, we're all good. And I'm not sure that they make a huge difference. All right, any other edits to the draft instructions beyond those that I've just incorporated?
Your Honor, on page 12 of the 155 instruction on reaching a verdict, I believe there's some references for each charge, and I would suggest that that might have been a carryover of the plural version.
The four-person
I have page 12, reaching a verdict, the third paragraph for each charge,
for the charge, yep.
and then has proved every element of the charge beyond a reasonable doubt, then you should find that Mr. Walsh is guilty of the charge or just is guilty.
Okay,
In the next
and
paragraph,
same thing, particular?
yes, Your Honor, particular, and then the on that charge.
I just ended it, not guilty.
Your Honor, on page 13, roll of the jury, second paragraph. Do not be influenced by the nature of the,
Charge?
yes, Your Honor.
I think I already made that change. I just didn't tell you I did.
Your Honor, on page 31, alternate jurors, I believe there's a reference to 3, and I believe it's 4.
It is, I made that change later in the day, Sue, and I didn't tell you about that either.
That's all the Commonwealth has identified, Your Honor. Thank you.
Anything additional from the defense?
No, Your Honor, content, except for the previous exceptions made.
Although now I think most of the previous exceptions you made have been removed,
Just being
but I get the point. All right, let me step off the bench quickly and make these changes. And the reason for that is I want you to each have a copy, well, to have a copy so that you can follow along while I'm doing it. Shouldn't take me very long.
All right.
Everyone all set? Good.
All rise. Jurors entering. Hear ye, hear ye, hear ye. All persons having anything to do with the Honorable Justice Diane Fournier, Justice of the Norfolk County Court, brought here, give your attention, you shall be heard. What's the call of Massachusetts in this honorable court? Please be seated. Please turn off your cell phones.
Jurors will start today, as we have every day together, with the 4 questions. Jurors, were you able to comply with my order that you not be on any social media or any news media?
Yes.
And were you able to comply with my order that you not do any research about this case?
Yes.
I will be able to comply with my order that not speak to anyone about this case.
Yes.
And you all still have open minds.
Yes.
Those 4 answers for the record all answered affirmatively by all 16 jurors in the box. We're ready to begin today's work. So as I promised yesterday, jurors, there's 2 chapters that will come interspersed now as we start today. And those chapters are that I will give you the instructions that are specific to the charge of murder here in this case. Then the parties will do their closing arguments. And then depending on how you're doing, given the time that's passed since then, we may have a short break, a bathroom break. Then I'll come back and give you the more generalized instructions on the law. Deliberately breaking into 2 chunks. It's more consumable for you that way. The jurors, I want to thank you for your service on this jury. To a person, when I've looked over, you caught me many times looking over at you. You've been paying attention, and that's exactly what I anticipated, but it's refreshing and rewarding for me to see it. So I know that you have paid attention to the evidence in this case, and I appreciate your attention. Your jury service in this case is a very important part of our democratic self-government. You are responsible to uphold the law and our principles of justice. That's what you promised to do at the start of this trial when you took an oath as a juror. You've all devoted a substantial period of time on this case, time away from your personal lives, your work, studies, your families, to sit as jurors in this case, and to decide the very important matter, an issue now between the Commonwealth and the defendant, Brian Walsh. You've done so in accordance with the finest traditions and the highest aspirations of our system of justice. Again, I thank you for your service and your sacrifice. You must now consider all of the evidence, decide who and what to believe, and decide whether the prosecution has proved beyond a reasonable doubt that Mr. Walsh is guilty of the crime of murder. The final part of this trial, as I said, will take place in those 3 steps. First, I'll give you on the law that is specific to the charge in this case. Then the attorneys will make their closing arguments, in which they will highlight the evidence that they think is important and will argue in favor of the conclusions that they ask you to make. Defense attorney, Attorney Tipton, will argue first, and the prosecutor, Assistant District Attorney Yaz, will argue last. After the closing arguments, again, I'll give you those generalized instructions that will help guide your evaluation of the evidence and your decision-making and your deliberations as jurors. And then you will work together to reach a unanimous verdict. Please pay careful attention to all of my instructions. All of my instructions are important and you must follow them, whether you agree with them or you do not. To make sure that I give you the instructions accurately, you can see that I'm generally reading them to you. You will also get written copies of the jury charge and jury instructions in the jury room when you deliberate the case. I do my best to make sure that the instructions that I'm giving you while I'm speaking match these written instructions. If there is any difference between what I say aloud and the written instructions, please follow what I say aloud. So let me start with the prosecution's burden of proof, and I'll start with the presumption of innocence. There is a fundamental rule that applies in all criminal cases, including this case. Every person who is accused of a crime is presumed to be innocent of that crime. Mr. Walsh is presumed to be innocent of the charge in this case. That means that you must consider Mr. Walsh to be innocent unless the prosecution has proved beyond a reasonable doubt through evidence presented at the trial that Mr. Walsh committed the crime charged. And I will explain what I mean by reasonable doubt in a minute. Mr. Walsh does not have to do anything to convince you he is innocent. He does not have to explain anything to the jury. Mr. Walsh does not have to testify, call or question witnesses, or provide any evidence at all because you must presume he is innocent. Instead, it is up to the Commonwealth to prove the charge against Mr. Walsh beyond a reasonable doubt. This burden of proof never shifts to the defendant. After you have considered all of the evidence carefully and fairly, if you have a reasonable doubt about Mr. Walsh's guilt on the charge of murder, then your verdict must be not guilty. You may find Mr. Walsh guilty of the charge of murder only if all 12 deliberating jurors agree that the Commonwealth has proved the charge beyond a reasonable doubt. So the burden is on the Commonwealth to prove beyond a reasonable doubt that Mr. Walsh is guilty of the charge made against him. What is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt, or everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proof beyond a reasonable doubt if, after you have compared and considered all of the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in this case. I've told you that every person is presumed to be innocent until he or she is proved guilty, and that the burden is on the prosecutor. If you evaluate all of the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, the evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. That's what I mean by proof beyond a reasonable doubt. There's one indictment or charge in this case. You must decide whether Mr. Walsh is guilty of that charge. For the charge of murder, there are certain things, we call them elements, that the Commonwealth must prove beyond a reasonable doubt to show Mr. Walsh is guilty. I will explain these legal rules to you now. There are two different degrees of murder: murder in the first degree and murder in the second degree. If you find the defendant guilty of murder, you shall decide the degree of murder. Commonwealth alleges that the defendant committed murder in the first degree on a theory of deliberate premeditation. To find the defendant guilty on this theory of murder, you must be unanimous. That is, all of the deliberating jurors must agree that the Commonwealth has met its burden of proving every element of this theory beyond a reasonable doubt. If you are unable to agree unanimously that the Commonwealth has met its theory of first degree murder, you shall consider whether the Commonwealth has proved the defendant guilty beyond a reasonable doubt of murder in the second degree. I'll begin by instructing you now on the elements and the additional requirements for the proof of murder in the first degree with deliberate premeditation, and then I will next instruct you on murder in the second degree. Murder with deliberate premeditation. To prove the defendant guilty of murder in the first degree with deliberate premeditation, the Commonwealth must prove beyond a reasonable doubt the following three elements. First, that the defendant caused the death of Anna Walsh. Second, that the defendant intended to kill Anna Walsh. That is, the defendant consciously and purposely intended to cause Anna Walsh's death. And third, the defendant committed the killing with deliberate premeditation. That is, he decided to kill after a period of reflection. I will now discuss each of those requirements in more detail. The first element is that the defendant caused the death of Anna Walsh. A defendant's act is the cause of death, where the act in a natural and continuous sequence results in death, and without which death would not have occurred. The second element that the defendant intended to kill Anna Walsh. That is, the defendant consciously and purposefully intended to cause Anna Walsh's death. The third element is that the defendant committed the killing with deliberate premeditation. That is, he decided to kill after a period of reflection. Deliberate premeditation does not require any particular length of time of reflection. A decision to kill may be formed over a period of days, hours, or even a few seconds. The key is the sequence of the thought process. First, the consideration whether to kill. Second, the decision to kill. And third, the killing arising from that decision. There is no deliberate premeditation where the action is taken so quickly that a defendant takes no time to reflect on the action and then decides to do it. Murder in the second degree. In order to prove murder in the second degree, the Commonwealth must prove the following elements. First, that the defendant caused the death of Anna Walsh. Second, that the defendant A, intended to kill Anna Walsh, or B, intended to cause grievous bodily harm to Anna Walsh, or C, intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. I will now discuss each of these requirements in more detail. The first element is that the defendant caused the death of Anna Walsh. The defendant's act is the cause of death. The act, in a natural and continuous sequence, results in death, and without which death would not have occurred. As you can see, the second element has three sub-elements, which I'll call prongs. And the Commonwealth satisfies its burden of proof if it proves any one of the three prongs beyond a reasonable doubt. The first prong, the defendant intended to kill, is the same as the second element of murder in the first degree with deliberate premeditation. The second and third prongs are different from any element of murder in the first degree with deliberate premeditation. The second prong is that the defendant intended to cause grievous bodily harm to Anna Walsh. Grievous bodily harm means severe injury to the body. The third prong is that the defendant intended to do an act which, in the circumstances known to the defendant, a reasonable person would have known created a plain and strong likelihood that death would result. Let me help you understand how to analyze this third prong. You must first determine whether the defendant intended to perform the act that caused the victim's death. If you find that he intended to perform the act, you must then determine what the defendant himself actually knew about the relevant circumstances at the time he acted. Then you must determine whether, under the circumstances known to the defendant, a reasonable person would have known that the act intended by the defendant created a plain and strong likelihood that death would result. let me give you some supplemental instructions relevant to the charge of murder. The definition of death. Death occurs when the heart has stopped long enough to result in complete and permanent loss of brain function. This complete and permanent loss of brain function occurs when, in the opinion of a licensed physician based on ordinary and acceptable standards of medical practice, there's been a total and irreversible cessation of spontaneous brain functions, and further attempts at resuscitation or continued supportive maintenance would not be successful in restoring such function. Next, the jury's obligation on guilt or innocence. You've been instructed on two theories of homicide in this case, murder in the first degree and murder in the second degree. If the evidence convinces you beyond a reasonable doubt that the defendant is guilty of a criminal offense, you have a duty to find the defendant guilty of the most serious offense that the Commonwealth has proved beyond a reasonable doubt. If the evidence does not prove beyond a reasonable doubt that the defendant is guilty of any offense charged, you must find him not guilty. Would either counsel need to see me?
No, Your Honor.
Be happy to see you. You take a, I know you haven't been sitting there that long, but you're going to go for a stretch now. So I'm going to ask you to stand up. As I said to you before, shake a leg. And when you're ready, please proceed. So, jurors, I'm about to conclude my first set of the instructions to you, and we're going to hear the closing arguments of counsel next. This is an important part of the trial because it's the final opportunity that the lawyers have to address you. It's an opportunity for the lawyers to summarize the evidence, to call your attention to certain parts of the evidence that they regard as important, and based on the evidence, to try to persuade you to reach a certain result. However, what you're about to hear is not evidence. Lawyers aren't witnesses. All of the evidence in this case has been presented to you through the testimony of the witnesses, the exhibits, stipulations, which you have before you. And as to the exhibits, you'll have an opportunity to examine those in detail and consider them during your deliberations. Our rules are designed to ensure that the parties receive a fair trial, and they therefore prohibit the attorneys from making certain types of arguments in an effort to persuade you to reach a certain result or to favor or discredit either party. For example, the lawyers are not permitted to refer to facts that are not in evidence in this case. If, based on your memory and understanding of the evidence, a lawyer does this, you should disregard that comment. The attorneys are not permitted to express their personal beliefs in the credibility or lack of credibility of any witness who testified in this case. That determination is entirely for you to make. If a lawyer makes such a comment, you should disregard that comment. This case must be decided based solely on the basis of the admissible evidence and the law that I'm teaching to you. Attorneys are not permitted to persuade you for or against either party by appealing to human passions or prejudices. If a lawyer makes such a comment, you should disregard that comment. If you become conscious of any passion or prejudice as you consider the evidence and engage in your deliberations, you must put these feelings aside and not permit them to influence your thinking. With that, we'll turn to the closing arguments. As is the custom, we'll hear first from the defense. Attorney Tippett.
What could happen? To a loving father and loving husband. We're making mind of please before you. Search for the unspeakable on the internet. Souls of the woman that you adore. Evidence suggests it was an affair. There's no proof of that. There's no proof that Brian Walsh knew anything about an affair between the woman he loved and William Dixon. Money? Second reason that the government suggests, family money? Money that the family had worked together for years and continued to talk about in text messages and the sales of property, trying to protect the assets for the benefit of the whole family and the future of the 3 children. A motive? There's no motive. Refusal to consider prison for a terrible mistake he made. The case that began in 2018, there's no proof of that he was afraid to go to prison. Who wants to go to prison? But prison was always on the table. And it was just something that he had to face up and something that he did. So what would cause a loving husband and a loving father to do the things that you heard about in this case? Could it be something that was sudden, something that was unexpected, something that was unbelievable, something that only a medical examiner would understand, have knowledge of, but not a man like Brian Walsh? Something that is terrifying, something that defies logic when it happens. How do we know that Mr. Walsh was a loving father and a loving husband? We know from much of the testimony of Jim Motlow. We know from simple testimony from Julie Basler from Kinderkind. When asked questions about her experience with Mr. Walsh and the children, that he would show up and he'd be interested and he'd be friendly, and he was always interested in the progress of his children. And how do we know he was a good father? Because Anna Walsh trusted him with their 3 children, 24 hours a day, 7 days a week, for all those times she was up in Washington, D.C. The unthinkable happens. It happens in a variety of ways. And the Commonwealth must prove to you beyond a reasonable doubt that a homicide occurred, that a killing occurred. Nothing proves that beyond a reasonable doubt on the facts and circumstances and the evidence given to you. There's evidence that he lied to the police. There's evidence that he searched the internet. There's evidence that he disposed of a body. But there is no proof in all of the evidence that you have heard from Dick Brzezinski that he ever once thought about harming the woman he loved, that he ever thought about harming the woman he loved, that he ever planned to harm, that he ever intended to harm. So when we talk about the evidence of the affair, when we talk about evidence of financial concerns, when we talk about evidence of being ready to go to prison, those are the motives that the Commonwealth needs to prove to you to support any notion that a loving husband and a loving father would kill his wife. And the evidence suggests there was no motive at all. And without a motive, without a reason that is based on facts and circumstances, logic and understanding, without that, you have a sudden and unexpected event that results in confusion, panic, and fear. All of those things that are so troubling and horrific that you've heard evidence about, they may be argued that they show consciousness of guilt. But people do things, terrible things sometimes, not out of guilt, but out of fear, out of disbelief, out of confusion. Certainly, a loving father and a loving husband would feel guilty about what he did do. Not just about lying to the police, but what he did do in the context of what he did to the woman he loved. In a moment, in hours, and in days of confusion and disbelief and horror. But that feeling of guilt had nothing to do with the killing, because he never killed Anna Walsh. You will hear arguments that you've seen the evidence that might evoke emotion. Who wouldn't feel emotional in what you've heard, what you've seen? But your obligation, and I don't mean to sound like I'm lecturing you at all. Her Honor will instruct you on the law, and that is not my province, but you cannot base your verdict on sympathy for Anna Walsh. You can't base your verdict on anger to what Mr. Walsh did. You can't base your verdict on passion, based on the evidence that you've heard that is upsetting and terrifying and at times disgusting. That's not what you can do as jurors in this case. At the beginning of this case, when you were sworn as jurors, you might not recall it, but the clerk of this court read you some words. To this indictment, the defendant pleads not guilty. Places himself before this country which you are. The obligation that you have accepted in this case is unlike perhaps any obligation that you've ever accepted in your life. Perhaps. That's for you to judge. But your obligation requires that without passion and without anger and without sympathy, that you assess the facts as troubling as they are, and at times as horrific as they are, and make your verdict rest on the evidence, and nothing less and nothing more. Unbelievable, facts that don't make sense at times, something that is incongruent. An example of that is the end of Mr. Jim Whitlow's testimony, where for almost an hour, he talked beautifully about the love between these two people. Then he talked glowingly about Mr. Walsh. And then toward the end of his examination, he wanted to say something about now he was thinking there might have been some kind of problem, and reflect upon the evidence that he gave of a phone call he had with Mr. Walsh on the 4th, when the conversation was confusing to Mr. Whitlow, confusing where he kept asking what could have happened that would result in Anna Walsh leaving. The lie that Mr. Walsh was telling people out of fear that no one was going to believe him about what happened, so he lied. But consider the way that Mr. Whitlow had a terrible time trying to understand that. And why? Because he knew both of them. Because what he was thinking, why would Anna Walsh leave? They love each other. I know them both. It makes no sense. And that is what happens when something happens that is totally confusing. You just can't believe it. And you seek answers. You yearn for answers that make sense of something. And when something sudden and unexpected happens, something tragic, your ability to come to terms with it, when it's such a dynamic, such a tragedy, you change. You change. The evidence of the searches, the dark, troubled evidence of the searches. They began at 4:52 a.m. on January 1st of 2023. The first one is, how do you dispose of the body? It causes chills. It causes disgust. Look at all of those searches. Think of how they evolved. Consider how they go from one subject to another in rapid fashion. Searches conducted by a man that is in disbelief, in confusion. 5 hours spending with his wife on New Year's Eve, enjoying life, talking about the future. And then a sudden and unexpected tragedy happens, and it doesn't make sense. If Mr. Walsh began to make those searches with murder in his heart as a result of murder, then why isn't the first search how to dispose of a body after murder? Because that's the search that occurred 6 hours later. And when you see that word murder, no one would not react to that word. And certainly as jurors in this matter, you're expected to react in a way to that. What does that mean? Does that mean that he in fact murdered his wife? But think about it in context. In this case, on these facts, context matters. And so the first time the word murder is used in these horrific searches is 6 hours after they began. And I tried to ask Trooper Garino, one of the forensic specialists, as he called himself, associated with the Mass State Police. I tried to ask him, well, it's only logical, isn't it, that if you don't get results, you change the wording. We all know that from our own common experience. And you look at those searches that came and went during this time, and the results had to do with funeral parlors and cemeteries and things like that. But Mr. Walsh, given the tragedy that occurred to his wife, and given the time that had passed and his fear and disbelief, he couldn't call a funeral parlor. You need to try to understand what can I do. Then the searches become darker, they become more upsetting. Now the thought is dismemberment. And there's searches like that. You've heard about them, you'll read about them. And then you see searches that cover days. And there's searches about cleaning, and there's searches about how to clean up. You'll read them. And even though they don't talk about murder, they are equally upsetting because you're thinking, as jurors in this case, he's thinking about cleaning up the basement. He's thinking about how you clean a concrete floor. Context. 1,034 pages of digital data, 3,667 records taken from his MacBook. Not one record, not one page refers to any plan. Not one record, not one page refers to any intent to kill. Nothing. So keep it in context when you review that exhibit and those searches, and ask yourself, why is a man searching now if he had intended to kill his wife? Why is the man searching now if he had planned to kill his wife? And that is the government's theory. He planned. He deliberately premeditated the plan to kill his wife. Where is the evidence of premeditation? In thousands of pages of records. I suggest to you respectfully, you're the jurors. What is the evidence of premeditation? There's evidence of a knife. There's evidence of a knife that is seen in a kitchen cabinet. That means exhibit 201. The next exhibit 202. And finally exhibit 203. The knife. It was above a refrigerator. It was in plain view. Had no visual red blood stain. And yet the government wants you to think about this knife. So think about it. Don't ignore it. Do not refuse to consider it. Of course you will, but think about it. In a cabinet above a refrigerator. And they first test it with some screening test. It doesn't prove it has even blood on it. And they take it and they shoot it. And then what happens is everybody loses interest in the knife. Everybody, the Mass State Police, the crime lab. There's no further testing of this knife. And ask yourself, if that knife is to be considered a weapon used, then why is it in that cabinet? You have heard evidence of bags and bags being thrown in dumpsters over a period of days. The government wants you to think that Mr. Walsh killed his wife and perhaps used this knife. Then why was it sitting in a cabinet days later in open view for the police? What logic is that? And there is no proof that it had one piece of biological evidence on it tied to any killing or any harm. And they simply lost interest in it. You can take it down. Digital data, talked about that briefly, but there is nothing in that data, all of that data. And we're talking about text messages. We're talking about MacBook searches. We're talking about the life that's embodied in computers that this day and age we know apparently keep track of everything we do and to some extent everything we think about. Because that's how the government is using that data. They ask you to look at certain things and indicate and try to argue that, oh, this is what he was thinking. So look at it and judge for yourself. What's in this data that demonstrates premeditation or intent to kill or intent to harm? You have heard and seen much physical evidence. You've seen pictures of gray slippers with blood on them. You've seen pictures of all kinds of physical evidence. And if the argument is made by the government, something about a dark gray slipper with blood on it indicates that a murder happened because, listen to the argument, of course you will. But a theory, an opinion, does not make it true. And to suggest something like, the evidence shows that Mr. Walsh went and bought a Tyvek suit, and maybe there's just not enough blood on the Tyvek suit to satisfy the Commonwealth, and so they suggest that some killing happened, and that's why there's so much blood on that slipper and those slippers and all that other evidence. But ask yourself, what do I know about that evidence now from what we heard? Every piece of evidence was put into a bag, but then was put into a compactor eventually and was pressed together and then found. And you will see all of this evidence of when they pulled it out of dumpsters and unloaded the bags, and they first put it on damp ground without any paper below it, without any tarp below it. And you heard from no less than 3 witnesses. Mr. Gould from the Mass State Police Crime Lab, Mr. Sheehan from the Mass State Police Crime Lab, and Ms. Salim from the DNA unit. They all consistently said cross-contamination or transfer. They use different terms, but they all agree. So the evidence, the physical aspect of the evidence, the thing you see in the photographs, the thing you see now, if you open up one of the bags and take things out, is not representative, or may not be representative of how it looked before. And you must consider that. So when the government makes an argument based on the state of the physical evidence as it appears now, ask yourself, maybe that makes sense, but maybe there's another way of thinking about it. And why is that important to your deliberations? Because you are allowed to rely on what's called circumstantial evidence. You're allowed to rely on inferences. And Her Honor will instruct you on that. I will not. But whatever reason and basis you have for making your choice and determining your decision must be reasonable. And if you, as jurors, talking amongst yourselves, find that some of your fellow jurors say, well, I think maybe it means this, and I believe this, and your other jurors, fellow jurors say, I think this, and I believe this, you'll all consider it. But if you don't agree, then you have to ask yourself, is that inference reasonable? Is that circumstantial evidence built upon inference? Is that reasonable? And can I use that? And should I use that to try to reach a verdict under a standard of reasonable doubt or moral certainty? What is the evidence that something violent happened in this house? I went through every room as best I could with Mr. Sheehan. There was nothing found in the upstairs bedroom. There was nothing found in the sinks and basins, showers, and multiple bathrooms. Nothing found, meaning biological evidence. It might indicate something violent occurred. There was nothing found in the kitchen other than a knife that they lost interest in. There was nothing found in the living room that had padding around the fireplace to protect the children from falling. There was nothing in that bedroom where Anna Walsh, Brian Walsh, as adults, enjoyed their life together and had spent their life together, perhaps every night before she moved to DC to take that job. How do we know that? We know that because the photographs show there was nothing there. Even what was characterized as red-brown stains on curtains in the bedroom turned out not to be blood at all. We know that because trained examiners from the Mass State Police examined probably every square inch of that house. We know that because we saw photographs in her testimony about floor that was dug up based on their experience and training. That biological evidence, like blood, can fall between the cracks of flooring and reside on the subfloor. And so they tore the floor up, and you saw those photographs, and you'll have them. And nothing was found. Nothing at all. I asked Mr. Sheehan about blood spatter, and he forthrightly and honestly said, I'm not a blood spatter expert, but he explained it sufficiently to you. Someone wielding a knife or a weapon and causes blood to let out of a body, and you look for blood that has spattered with directionality. Nothing. Nothing in the bedroom, nothing in the living room, nothing in the bathrooms. No evidence that blood drained down the drains. Could I have exhibit 217, please? That test that I asked Mr. Sheehan about, the Serotek Hem test, that checks for hemoglobin, for blood. That test, he agreed, can detect blood at the sensitivity of 20 nanograms per milliliter. 20 nanograms. A nanogram, as he agreed, 1/1000th of a gram. Think of how minuscule that is. And they used that all over the house. And so the government elicited questions and answers from many of their state police, the 10 or 20. They didn't call everybody. That's up to them. But apparently there was no need to, because 10 people or more, as Mr. Sheehan had described to you, he was estimating. He was trying to be as honest as he could and credible, and he was. 10 people pouring over that house all day on January 8th. 10 more people or more pouring over that house on January 9th with their tools and their experience, and they don't find anything except multiple bloodstains where? In the basement. In the basement. On the concrete floor. Ask yourself, when you heard testimony that Mr. Walsh attempted to clean, and so therefore they couldn't find evidence in the other parts of the house because he cleaned it. Well, ask yourself, wait a minute. Is that logical to suggest that he cleaned the bedroom up so well nobody could find a thing? He cleaned the living room up where the rug may have been, and they couldn't find anything. Well, then you see those searches where he searches specifically for how to clean concrete. So you might infer, and it might be a reasonable inference, that he attempted to clean that concrete floor. And yet, what was found on the concrete floor? Multiple red-brown stains that turned out to be blood, and in some instances, we can all agree, based on the testimony of Ms. Celine, the profile, those blood drops matched the profile of Anna Walsh. So to suggest that Mr. Walsh did everything he could to clean the basement concrete floor with hydrogen peroxide and mops and cleaning fluids, only to have blood found on the floor, defies a reasonable inference that he was able to clean any part of that house sufficiently to avoid detection. And why is that important? Because nothing violent happened in that house, and that's why there is no biological or blood evidence anywhere in that house. The act of trying to hide the body of blood and the blood evidence that is seen on that carpet. That's what happened. There's no blood in the living room. The inference might be that the carpet was taken downstairs. Because you can look at those pictures. You can look at the physical pieces of carpet, and you should. But there was no evidence of any killing that happened. And there's no evidence that anything was done before Mrs. Walsh died. And there's no evidence of premeditation or anything. There is evidence of lying and disposing of the body. You can take that one. So now we look at the evidence, and I'm just going to characterize it. Some of the evidence that the Commonwealth has presented to you, and there is no question that their obligation is to present you evidence. But I just ask you to think about, in some cases, how that evidence was presented to you. And I'm going to use a phrase that may or may not be entirely accurate, but it's cherry picking. It's looking at thousands of points of data and asking you to think about it, but not telling you why you should think about it. And what am I talking about specifically? And I'll give you some examples. We already talked about the hole in the ceiling, but let's talk about it a minute. They kept talking to you about that hole in the bedroom ceiling as if it was of some significance. And yet you recall the testimony of Mr. Sheehan. I didn't see anything significant about it. It looked like somebody might have fallen through the ceiling. And there's nothing significant about the pieces that Mr. Walsh had stored in the cabinet in that same bedroom. I asked Mr. Sheehan about that. I didn't see anything significant about that. Yet you kept being given that evidence. And then as the evidence developed, for some reason, there's Mr. Murphy. And it came out in evidence that Mr. Murphy had in fact contacted Mr. Walsh because there was a promotion going on. It wasn't that Mr. Walsh said, hey, come and fix this hole, this suspicious hole. No, he was contacted. And he didn't respond right away, but then he did. And for some reason, they keep insisting that that hole is of some significance, but they don't tell you why, they just give it to you. They do the same thing with the searches. Remember when Trooper Chief was sitting right here and he's asked to look through those thousands of, 250 pages of the search history from the iPhone Mini 13, the phone that belonged to Mr. Walsh, and he's asked to look at it and says, do you see searches there to go to the MGM? Yes, I do. Nothing else. No explanation why that is significant, why it's important to try to determine if a man committed premeditated murder. You're just throwing out pieces of evidence. Why? Why were you given, why was Trooper Keefe asked to tell you about a song, a partial song title? And when you go over that evidence, look through there if you choose to, and I encourage you to do that. And you see song after song and movie title after movie title. Why is it that the government throws that at you and says, think about this? For what reason? And then they present to you through Trooper Garino something about a porn movie. I'll just take this opportunity right now to apologize to each and every one of you for some of the questions I asked. But it just didn't make sense that you would take that type of evidence and suggest that it has anything to do with determining whether someone committed deliberate premeditated murder because there's a word in the title of a movie. And that's what I'm talking about, the quality of some of the evidence here, thrown at you as if it means something, that it's significant, and yet here you are being asked to determine if someone, Mr. Walsh, committed premeditated murder with a specific intent to kill the woman he loved. When we talk about premeditated murder, we talk about planning, you have to ask yourself, did I hear evidence of the conduct of a man who premeditated, a man that had thought about a killing, a man that had planned? I mean, think about what you heard. And we're not going to repeat all those things I've already said, but I want you to focus on one other piece of evidence. I asked Detective Schmidt, when you went down to the basement on January 4th, you saw some bags down in the basement. Yes, I did. What did you think was in those bags? I thought they were pieces of rubber. My goodness. What does that tell you about the thinking process and the sloppiness and the lack of any planning or careful thought that you would expect out of someone who had planned a murder? And then he lets a police officer walk down in the basement, and the police officer, based on his training and experience, uses, I think he said, his boots, and he felt it, and he said, felt like pieces of rug to me. Rug? That is in evidence? It has blood. Think about all of that when you're thinking about it. Did this man, Mr. Walsh, did he plan anything? No. Did he intend to kill anybody? No. Did he kill Anna Walsh? No. The evidence does not support finding a premeditated murder with specific intent to kill based on the evidence, not based on sympathy, based on the evidence. What's some other evidence that is troubling? Mr. Walsh is talking to the police, and he says, I messenger. When asked about, and we try to explain it, things will come up on my phone that I thought were for me, but then it turns out they were for Anna. And so the government seizes upon that evidence and suggests that there's evidence that Mr. Walsh had seen text messages between Anna Walsh and William Fastow. And those text messages between Anna Walsh and William Fastow, some text messages are placed into evidence, and I'm sure you'll look at them. And why would the government want you to believe that Mr. Walsh saw those text messages? Because some of the entries in those text messages are very upsetting. They may very well enrage a husband to read about what was going on in those text messages. So you'll look at them. But ask yourself, as you look at them, and perhaps as you think, I could see that might upset, that might put somebody in a rage. Problem is, there is absolutely no evidence Mr. Walsh ever saw any text message because he was trying to say, I messenger. And now you know from the testimony of Trooper Keith, there's no such thing as I messenger. We're talking about Facebook Messenger. But the important thing is, there is no evidence in all of the digital data that you have before you, in all the digital data that they examined, that Mr. Walsh ever saw anything going on between his wife and William Fastow. And when you look at those text messages, and you might have some question about it, and if the government stands up and says, well, he saw those because he told them that he was seeing iMessenger, which doesn't exist, then ask yourself, why is it then that on New Year's Eve, Anna Walsh is taking all these photographs? It's festive. It's a lovely situation. And she says, in the presence of Brian Walsh, as she and Jim Mutwell were taking photographs, hey, why don't we send a photograph to Will Fastow? And was there any evidence that he reacted, Mr. Walsh? No. And when asked by Attorney Porges, well, so what happened next? And Mr. Mutwell really took efforts to remember, and then he said, oh yeah, that happened right before the young boy woke up and came downstairs, and that was around 10:30. So if you just think about that, then the festive and jovial celebration continued for another 2 hours. There is no evidence that he reacted. Mr. Walsh reacted to them sending a photo. Why? Because he knew his wife had a crush on Will Fastow, and it didn't even make him jealous. And how do we know that? Because she told her friend, Alyssa Kirby. And Alyssa Kirby was asked, and she said, Anna told me that he didn't get jealous. He's not the jealous type. In fact, I wish he was more jealous. Please consider that in the context of this notion that the motive for a killing that did not occur, but the Commonwealth's theory of a motive is anger over an affair. There's no evidence of that. Dr. Atkinson told you. Dr. Atkinson described to you the phenomenon of sudden unexpected death. It happens. And just because it's rare, and just because the government will undoubtedly argue that that is nonsense, listen to their argument. But Dr. Atkinson made it clear it happens. It happens in young and old, male and female. It happens unexpectedly. In fact, it happens with people who have never manifested any problem before. It happens in athletes. And how do we know that it's not absurd, even though it might be rare? How do we know it is an important aspect of what happens to people? Because the laws of this state mandate that the office, the chief medical examiner, get information from doctors, police officers, nurses, when there is a sudden death, when someone is otherwise healthy. They're mandated to investigate that. So there is a statute that Dr. Atkinson told you a little bit about on cross-examination. So ask yourself, is it as unlikely? Is it bizarre? Because Anna Walsh worked out. Yes, she had been sick before. She had been with Alyssa Kirby in the days leading up to this, and Alyssa Kirby wound up having the flu. But that's not what really is at issue here. Sudden and unexpected death may occur because someone is ill. All we know is that it happens. And the fact that someone doesn't believe it could happen, doesn't mean that it doesn't. Importantly, though, think about the shock of it happening. Think about the effect it would have on anyone. A layperson that has no idea it could happen. You're down celebrating with your wife and your friend, and then the tragedy happens. And you panic because you can't believe it. You don't understand it. And you don't think anybody's going to believe it. Context. I walked Trooper Keith through all of that information, something that he had not done yet. And so what did you hear? We went methodically. Sometimes, I'm sure for some of you, it was a little painful. It took a little while. But we went through hour by hour, day by day, that basically was the life and the experience that Anna Walsh and her husband, Brian Walsh, were going through in just the days leading up to January 1st of 2023. And what do you see? And you'll have that evidence. You won't have it compiled in the way that I presented it to you, because Trooper Keith never saw fit to assemble it in a way where you could really see what was going on. But what do you see, and what did you learn from the evidence? Two people communicating by phone and by text, talking about sales of property, talking about investments, talking about the future, talking about reinvesting, talking about buying new property in DC, talking about all of that, and it's all in the text. Joking when Anna Walsh was ill and stayed home and told her husband that in the text. And then they joke about it. I'll get you a plunger. And she responds, it's right there on the text. Joking back and forth in the days leading up to New Year's Eve. I'll tell you what, I'll buy the plunger. You buy me a Porsche. And then you see him shopping for a Porsche for the woman that he loved. How does it go from, I'm going to find you the Porsche you want? It speaks once again to the financial issues that were non-existent. How does it go from that to someone who is poorly premeditating and intending to kill his wife? And those texts lead right up until she arrives by plane in Cohasset to celebrate. So, context. Once again, divorce? About 11 minutes of talking about divorce and searching about divorce and 7 days of phone calls. And how did that divorce search come up? It came up in the context of protecting the family assets because they just sold the house in Revere that Jim Mutlow told you about. And they're trying to protect it. And the thought is to roll it over in a 1053C. And Mr. Mutlow explained that to you. Planning for the future. That is the relationship between Brian Walsh and Anna Walsh in the days leading up to January 1st. So now we have come to just the evidence that, once again, this explains their relationship. Not supposition. Not trying to make up what they said to each other. You have that in their text. You have that. Then we get to New Year's Eve. We get to a festive event, jovial, laughter, love, described in various terms, various ways. Not for 30 minutes, not for 1 hour, but for 5 or 6 hours. Laughter, talking about the future. Jim Mutlow described it for you. Brian Walsh cooking, standing across from the island, feeding both of them, talking, laughing. You see in the testimony that, yes, there was an affair. He didn't know it. He loved his wife. He treated his wife like the wife he loved, the mother of his children, until the sudden, unexpected event happened. Imagine, you are so in love. You support your wife to get a job in DC. You're going to take care of the kids because, one, you love your children, but you want to take care of them. You want to share property and protect the assets, so everything goes into her name. To protect, because he has this federal case. So let's protect our financials for the future. And then you hear the testimony of Alyssa Kirby. Yes, she was upset. There's no doubt Anna Walsh was upset. What exactly she was upset about? Maybe things weren't going really well in the affair she was having. Or maybe she was, in fact, stressed out. Who would be? It's up to her. Anna Walsh was a wonderful mother, and that's why he loved her so much. But she had another life, and she went to Dublin, and that's another piece of evidence. They want to suggest to you he knows something about Dublin. Where is the evidence of that? None. And you hear Alyssa Kirby choked up with tears, sobbing on the stand, but nonetheless recalling the conversation she had on 12/29, 3 days before January 1st. What does Anna tell her? Well, I don't know if I love him as much as I used to. Those are her words. I'm paraphrasing, but that was the gist of it. But I want him to take responsibility. Why? Not so she could kick him out, not so she could leave him, so they could reunite as a family. That was what Anna Walsh was talking about. That's what she was thinking, even though she was stressed, even though she was upset. And things like that happen in families, but families make it through. And that's what she was expressing. That's what she was expressing. Her best friend, Alyssa. Her. Did I get it? We are now at the end of the New Year's Eve party, and they signed the champagne bottle. And we were talking about the feelings and the emotions and the state of mind of Anna Walsh and Brian Walsh, and looking towards the future. And this is on January 1st. This is on the day that the tragedy happened. Can you find it? I'm sorry, 169. Oh, I apologize. Michael, I'm sorry. Is it 257? And that's the champagne box that was signed. And what are the words? What a year. And yet we are still here and together. Let's make 2023 the best one yet. We are the authors of our lives. Courage, love, perseverance, compassion. Those are the words of Anna Walsh talking to her husband. Look what she says. What a year. And yet we are still here. What does that tell you? Yes, they had been through a lot. She missed her children. What mother would? But they were working toward the future. And one final thing about the state of mind of Brian Walsh at this period of time. He made reservations for a New Year's Day dinner so he could be alone with his wife. And the evidence of that is in these records. And I'm not going to have it called up. I'll just tell you. Exhibit 79, page 186, record 682. That's the data. He's researching where to take her out. And you'll see a reference to Nightingale, a restaurant that I asked Trooper Keith about. A restaurant that's right on the line of Marblehead Inn. Exhibit 59, at 1227, those records indicate that Mr. Walsh credit card used to reserve dinner for $573.76. So him and Anna could spend New Year's Day celebrating. And exhibit 170, a text from Nightshade Restaurant itself acknowledging the reservation. And those were the plans that he made. And the government will suggest that's some kind of evidence of premeditation. Well, it's not any evidence of anything but love. And I'll just tell you, when you look at that evidence, you'll see that that email exchange was deleted. It's right there in the evidence. And then you heard the federal probation officer saying he wouldn't be allowed to go there. He'd have to get permission. So yes, Mr. Walsh lied to his probation officer for what reason? So he could take his wife out for a New Year's dinner, and that evidence, and the evidence that you saw in that champagne box, is what their life was right at the moment before the tragedy happened. That is the evidence. I'm sorry I talked for so long. I apologize. Mr. Walsh loved Anna Walsh, the mother of his 3 children. There's no evidence that he deliberately premeditated a murder. There's no evidence that he ever intended to kill Anna Walsh. None whatsoever. Mr. Walsh is not guilty. He's not guilty. Thank you.
Jurors can't, so I can take a moment to stand up. Everyone good. When you're ready, you may be seated. And here's the closing argument of the Commonwealth. 80 yes. You may proceed.
Thank you, Your Honor. Anna Walsh is dead. Anna Walsh is dead because he murdered her and he intended her death. Anna Walsh is not missing. She never walked out of her class at home on January 1st of 2023 between 6 and 7 a.m. to take an Uber to Logan Airport. She wasn't going to DC for a work emergency. There was no emergency. She didn't say goodbye to her son. It's just a story that the defendant told people. But since January 1st, Anna Walsh has not been seen by her friends, her coworkers, or by the people who loved her. Anna didn't take an Uber. She didn't take a Lyft. She hasn't used her phone. Her phone's had no contact with the Verizon network since January 2nd, 2023, when it was in the vicinity of 516 Chief Justice Cushing Highway. She hasn't used her bank accounts, her passports, her credit cards, her email. She didn't vanish. The defendant was the only adult at 516 Chief Justice Cushing Highway after Jim Lulu left around 1:30 a.m. on New Year's Day. After he left, Anna was home alone with the defendant and their 3 sons, ages 2, 4, and 6. This defendant caused Anna's death, and the evidence does show you that. The evidence shows you that Anna didn't die of natural causes, but that Anna died a violent death in her Cohasset home on January 1st. You have the photos of those pieces of rug recovered from the dumpster at the defendant's mother's complex. The rug that had been in the living room. You have the photo of Anna in the living room on top of the rug. And the photo shows that there are wood floors in that room. There's blood on that rug. The rug was recovered from the compactor outside of the defendant's mother's apartment and taken to the office of the chief medical examiner for examination. And Dr. Atkinson found a blood clot and a piece of Anna's Gucci necklace embedded in one of the cutout pieces of rug. So look at the piece of metal stamped Gucci. It didn't break on its own. The rest of the necklace is missing. This is the necklace that Will Fastow said that Anna often wore. Look at the slippers from the dumpster. The 2 pairs of adult slippers. The dark gray slippers have hair and blood clumped to the bottom. And the DNA testing tells you that the slippers have the DNA of Anna Walsh and the DNA of the defendant. Then there's a bathrobe. And there are 2 bloody white towels. A towel was tested that had Anna's DNA. Why did the defendant throw those items out? Because they had Anna's blood on them. And the evidence shows you this because the defendant was researching cleaning. How to clean blood from what floors? Does dishwasher clean blood? Is it possible to clean DNA off knife? The defendant still had a cut on his thumb on January 9th, 2023. And on January 1st, before he even went to Lowe's to buy any cutting instruments, an initial stop that he made when he left his house was to go to Walgreens to buy antibiotic ointment and Band-Aids. Then he went to Bin and Liquors, where the manager identified the defendant, and the defendant threw a bag into the dumpster. Store is closed, the parking lot is empty. He's not yet gone to Lowe's. On January 2nd, 2023, the defendant went to Home Goods because he had to buy a new rug for that living room to cover the hardwood floor. He did this days before the forensic scientists got to the house and knew that the rug had been changed. Anna Walsh dying a sudden death from natural causes defies common sense. She was in great shape. The defendant told police that Anna was a sturdy Serbian woman. Listen carefully to his recorded interviews, because those are his words after her death, after he killed her. Mark Salvaggi told you that Anna had the highest health rating of the life insurance company. Anna had to complete an interview, have blood drawn, provide her medical records, and the life insurance company and the underwriters gave her this health rating. Anna was an active person who took care of her health. Ashley Samino, her bar instructor, told you about this exercise class that she took the morning of December 31st, 2022. And Anna was the type of person, she said, who made others want to work harder in their exercise class. Will Fastow told you that Anna was very active and did yoga together. Sergeant Amy Waterman described Anna's home gym in BC. And Dr. Atkinson told you about the different ways a person can die, and that it's extremely rare for a 39-year-old in good health to suddenly die of unknown causes. But without a body, it's not possible for the medical examiner to tell you the exact cause of Anna Walsh's death. No autopsy can be done. The defendant deliberately got rid of Anna Walsh's body. The defendant did not want anyone to find Anna's body and to know how she died. So the defendant bought cutting tools at Lowe's and Home Depot, and he cut up Anna's body, the woman that he claimed to love, and he threw her into dumpsters. He was hiding her body. The defendant intended to kill Anna Walsh. He didn't just want her dead, he needed her dead. This was a marriage in crisis, and it was heading towards a breaking point. It began with the defendant's federal case. And through the defendant's interview and his federal probation officer, you learned that the defendant was on home confinement. He was going to have to pay over $400,000 in restitution, and the case had been pending since 2018. You also learned that the defendant had no assets. He told Jamulu that he only made $50,000 to $60,000 that year, but he had told the police that he had businesses that were not making any money at all. Peter Capozoli told you that the defendant's mother signed the lease for the Cohasset home, and it was his mother that was paying his rent. Meanwhile, Anna was beginning to thrive. The marriage was beginning to deteriorate. Anna had her dream job. She had risen to become an executive at Tishman Speyer, and she was making close to $300,000 a year. She earned a bonus. And Teresa Marchese said that Anna was a good employee. And the defendant knew this. He bragged of her bonus and salary. She bought a townhouse, and she furnished that townhouse for her family, and she set up bedrooms for each of her 3 boys. But the reality was, the family couldn't join her because the defendant needed the children with him. Being the primary caregiver allowed him to afford prison. The separation of the defendant and Anna was taking a toll. Anna wanted the children with her. And Anna began a relationship with Will Fastow, which became more serious. The defendant and Anna were growing apart emotionally and physically. Anna struggled not having her children and not being able to be the mother that she wanted to be. This got worse when Anna took the trip to Serbia to take care of her sick mother. Anna and Will Fastow spent the Thanksgiving holiday first in Dublin before Anna went to Serbia. And Anna bought a plane ticket with the credit card that the defendant monitored. And the defendant told police that he monitored their joint Chase Freedom credit card statement. The MacBook history also shows the defendant looking at the Chase account. The defendant knew about Anna's travel because in a recorded interview, he told the police that she had a layover in Frankfurt, and that connection in Frankfurt is on the same credit card statement. And you can see that, it's right in front of you. The defendant was angry about Anna missing Thanksgiving. He mentioned it repeatedly when he spoke to investigators.
I got angry about Thanksgiving, and then I realized it was just sad that we're not spending a lot of time together. And she was sad about it too, and it was exhausting for both of us. She was away from the boys, I was always away from the boys.
Anna returned from Serbia in December, but she only spent 1 day in Cohasset. And she was supposed to come home for Christmas morning, but she missed her early flight, and she couldn't get a flight, and then she had to drive up. The defendant told police there was an argument.
I did have an argument with her for the Thanksgiving and then Christmas Eve, so I wasn't going to make the same mistake 3 times.
So what did the defendant do on Christmas Day when his wife wasn't home? He looked up Will Festa on his cell phone, the man his wife had just spent the night with. The defendant was losing Anna. Anna was missing her children and wanted to be them. Anna quickly returned to DC, and on December 27th, the defendant was looking up the best strategies to divorce for a man and the DC divorce laws. This was not to protect assets. That wasn't the search. The defendant told the police that everything was in Anna's name. The defendant had nothing without Anna and the kids. And on December 29th, Anna spoke with Jen Maru and told him that she was upset about the travel, upset being separated from the children, upset about the defendant's schedule. It was ongoing. It's getting to be too much. On December 29th, Anna went out with Alyssa Kirby. And she broke down. This strong Serbian woman who was supposed to be having a fun night out with a girlfriend, going to dance karaoke, instead broke down. Anna told Alyssa that she had told the defendant that he needed to take responsibility for the federal case, go to prison. She wanted the children with her in DC, and she and the defendant had not been intimate in close to a year. In Anna's mind, the marriage was broken. Anna even questioned if she could just take the children because she had already established a separate household. She said that she was falling out of love with the defendant. And at home in Cohasset, what was the defendant doing? He was looking up the Mazda building and the FBI raid on the Crossing building, looking up something that had happened in the spring of 2022 when Anna first started working for Tishman Speyer. Interestingly, this was when the defendant brought up something he brought up in his interviews when he lied about Anna having to leave early for a work emergency. He was planning the work emergency. The defendant was going to lose Anna, and when he lost Anna, he would probably lose his freedom. Anna would have a house in DC and a nice job, and he would likely go to jail. So the defendant pretended. He lulled Anna into thinking that everything was okay. He joked with her about abortion. He didn't want her to realize that he was aware of the relationship with Bill or her ability to leave him. He wasn't going to let Anna know that she wasn't safe. On December 31st of 2022, the defendant claimed that he could not find his phone. Why is that important? The mislaid phone allowed the defendant to be unavailable for 2 days. The mislaid phone allowed him to carry out his plan uninterrupted. And the mislaid phone allowed him to show the police when he eventually reports Anna as a missing person and not have the police question why he didn't contact Anna earlier. The evidence shows that the defendant was methodical. Just look at how he shopped at Lowe's with a list. He planned it with precision. So Jem Lulu came over for dinner on New Year's Eve, and the defendant told Jem that his phone was lost and it was free. Anna was texting throughout the night, including with Will Paxton. This is now the third holiday where Anna was concentrating on the other man in her life. When Jem left, Anna was alone. She was with the defendant, the man she was cheating on, the man she was telling to take responsibility for his actions, and the man who had her children. The defendant murdered Anna that morning in their Cohasset home. And this is what the internet history shows. His internet history, written words. He was looking at best way to dispose of a body. Better to throw away crime scene clothes or wash them. Crime scene. Can you be charged with murder without a body? Anna was dead. The defendant killed her, and he began researching how to get her money, how to inherit, how to get away with the crime. And he might have gotten away with it, but he didn't know that his MacBook was syncing with his son's iPad, the same Apple ID. His demeanor changed during the interview on January 8th when the police mentioned the searches on the iPad. Not because the iPad involved his children. He had already involved the children in his lives, but because he knew he was caught. We know he had already involved the 6-year-old when he had the 6-year-old say that he saw his mother when she left the house on the morning of January 1st. The son could not have seen Anna leave the house. The defendant had already killed her. Listen to the recorded interviews. During the January 5th interview, the defendant spoke about what his son supposedly had seen. And the defendant involved the 4-year-old by saying that the 4-year-old hid the defendant's iPhone 13 mini. So, the defendant's phone made a reservation at Nightshade Noodle Bar for New Year's Day, after the defendant told Anna that they were going to have a special party. This was ironic because the defendant was very clear with police on January 7th that he and Anna had no plans for New Year's Day, and the defendant also knew that he would be violating the terms of his federal probation by going to a restaurant on New Year's Day. But let's look closely at Exhibit 170 about the Nightshade Noodle reservation, which was on the defendant's iPhone Mini 13, which the defense just said was deleted. And if you look on page 2, on the bottom of one of the bubbles, you will see that the message was deleted on January 1st at 7:59 and 5 seconds a.m. This happens to be one of the times that the iPhone Mini 13 was unlocked when it was supposed to be missing. The forensics showed that the defendant's phone was unlocked 4 times and it was plugged in on January 1st. You heard testimony that the phone had a password of 197512. And in the January 4th recorded interview, you hear the oldest child needed help with his iPad password, which was 121212. The children didn't unlock the defendant's phone. The defendant blamed his misplaced phone on one of his children when he said that the children hid it. But it makes no sense that a 4-year-old somehow unlocked the defendant's phone and deleted that text reminder. Listen to the defendant's recorded interview. The deletion is made when the defendant is supposedly making French toast and playing with the kids. The defendant had access to his phone. Context. The defendant also had access to 2 other phones when his phone was supposedly lost. He had Anna's phone and he had the iPhone SE. And in the recorded interviews, the defendant told police that on New Year's Eve, Anna had an argument with a friend, and as a result, Anna put her phone upstairs in his bedroom.
You said she must put her phone upstairs after that?
After that, she was there 10 or 15, and then she I remember putting her phone upstairs because she came back down without it.
Was Thomas came down at one point and hung out with the
Yes. Yeah, exactly.
Was this before, during, or after Thomas was staying?
Oh, yeah, Thomas went to bed at, he went to bed when he came over at like 9 or 10 or something. I think Anna took a bunch of photos. Jim and I don't have any because she didn't send them to us yet. But I think she sent one to Will Fasto. So that was when, that's when the photo was taken about. So it was 10 o'clock or something like that.
You know, where our station put our phone there.
Yeah, that's it.
That's not what Jem said. Jem said that Anna was using her phone all night. Melissa Kirby texted with Anna. The defendant was telling investigators a story about Anna's phone. How else do we know that the defendant intended to kill Anna and had a plan for doing so? Look at his internet history. Look at what he did. The defendant set up an area in his basement where he surrounded it with plastic sheeting, wore a tie-back suit, and dismembered his wife, the love of his life. Hacksaw, the best tool for dismembering a body. Then, the defendant got rid of Anna's body. He got rid of her belongings. He got rid of her clothes and bag that he told police that she had when she supposedly left on January 1st. He threw her in the garbage bags, tossed those garbage bags in different dumpsters. Disposing of her body in the trash. Chatham West, apartment number, the Claremont apartment number. And please confirm this with the location data from the SE phone and the iPhone 13 mini. The evidence shows that the defendant did this to hide the fact that he murdered Anna. He could not let Anna's body be found because Anna didn't die of natural causes. The defendant murdered Anna, and then he had to hide the evidence of his crime. His mindset, within his internet history, want to get away with murder, use a special detergent. Can you be charged with murder without a body? Best way to dispose of body parts after murder. When you deliberate, look through the binder of the MacBook internet history. There are no searches of natural causes of death, sudden death, heart attack, aneurysm, stroke, or how to help your children when someone dies unexpectedly or goes missing. The defendant was not sad. Look at his demeanor in the surveillance videos. He's cool and calculating. He's calm. He had plans. On January 1st, he went to the Lowe's store an hour away, even though there were hardware stores approximately a mile from his house. And when he was in Lowe's on January 1st, he wore a mask and he wore gloves and he had a list of what he was shopping for. He was calm as he helped bag the purchases. A hacksaw, buckets. He used cash. Does this show confusion, panic, or fear? But he doesn't stop there. He went to CVS to buy hydrogen peroxide, and then he went to Stop and Shop to buy ammonia. No wonder the house was so clean. And on Monday, January 2nd, he went to Home Goods for rugs and candles. And then he went to Home Depot, where he bought buckets with lids this time, baking soda, and a hatchet. And at some point that day, he got a call from his probation officer, and he lied, and he said that he was picking up his children. He was able to calmly speak with her. No panic. He had everything now that he needed to dismember the woman that he supposedly loved. And he started to take her body and to throw it into dumpsters, since he had to cover up the crime to get rid of the evidence of the murder. This was not a man in crisis. This was a man who on January 4th went to TJ Maxx to buy pants with the store exchange card. He was calm. But Alyssa Kirby texted him on January 4th asking about Anna, and so he called Tishman Spire a few minutes later and started to pretend to look for her. He called Will Fastow, but he didn't leave a message. He called back later, and then he calmly left a voicemail. No panic. The defendant knew where Anna was. The defendant even texted Anna's sister in Canada and said that she was missing. He was methodical. Look at the text messages. And at 4:30 p.m. on January 4th, the defendant went to Lowe's to buy a trash can. Comfortable, not panicked. The police would come to the house and talk about Anna. And the defendant had the house ready. The police think his wife is in D.C. He had his phone ready, and he sent text messages to Anna, even though he knew she would never see him. Despite everything that he had done on January 2nd, the defendant wrote a text message to Anna. I still love you. Ha ha. His joke. The defendant prevented anyone from ever finding Anna's body and no autopsy. Dr. Atkinson told you that the medical examiner can't do an autopsy of our body, and all that remains of Anna are 2 hairs, some blood, and a few things that belong to her. Part of the necklace she often wore, her hunter boots, a black jacket, a purse, her coat card, and a few other items in the dumpster in his mother's apartment complex. The defendant searched his MacBook for a murder conviction without a body. Please do not allow the defendant's self-serving act of dismembering and disposing upon his body to let him get away with this murder. At the start of this trial, we asked you to use your common sense. When you do that, when you analyze the evidence as you deliberate, and continue to use your common sense, you will see that the evidence shows there is only one verdict. Find the defendant is guilty of the premeditated first-degree murder of Anna Walsh.
I will see counsel at the side of the bench. George, you're my guidepost. Do you need a break for the bathroom? Okay. All for one, one for all. Need a break for the bathroom. Let us know when you're ready to come back out. I'll be at your disposal.
All right, please. Jurors, follow me.
Seated. We'll give you a quick break as well, but something's been on my mind that I want to discuss now that the closing arguments are over. And that is, I had asked in connection, this relates to the sentencing, at least for the other two counts. I asked the Commonwealth to provide victim impact statements for any immediate family members of Anna Walsh that wish to provide information, and I haven't received that yet. And there might be a good reason for that. I told you that I was putting off the sentencing until we had a verdict on the charge of murder. Now that it's a Friday, and I don't want this to linger over into the next week, has the Commonwealth heard back from the Department of Children and Family Services?
Your Honor, we've been in touch with them. They are working on their impact statement. They were hoping to have the impact statement impounded. And I can, as soon as we're done here with the charge, I will speak to the attorney that I've been dealing with. They've been working very hard on this. They're certainly worried about their privacy interests of the children and the
I think
social
there's a valid privacy interest of the children, and I'm highly likely to impound it, obviously, with the exception of counsel for both sides being able to see it so that they can make appropriate arguments as a result of the victim impact statement.
I think the department will be very happy to hear that. And they also, much of what they have is through a social worker privilege, so they're concerned about that as well. But as soon as we break, I will be happy to have that conversation.
Well, I'm happy to hear that there's forward progress because I guess I assumed, because I hadn't heard anything, that you were still not getting the answers to the questions you were asking.
No, quite the opposite. They've been working very hard on this.
All right, I appreciate that.
Thank you.
Anything anyone needs before I step off the bench briefly? Thank you.
All right.
Yes, please. I just so it's on the record, everybody saw the small edit I made for the verdict slip and everyone's fine, is that right? Everyone's not. Thank you.
All right, to the court, please. Jurors entering. Close back to session. May be seated.
Welcome back, jurors. Jurors, I'm going to go through the remainder of the instructions, the final stage of this case before you will get the case to deliberate. The intent of the second part of the instructions is to give you some assistance in determining how you go about deciding whether the Commonwealth has proven each element of the indictment is true beyond a reasonable doubt. For the charge, you must decide whether the Commonwealth has proved beyond a reasonable doubt that the defendant is guilty of the charge. You may not find the defendant guilty on the charge just because you think the defendant did something else that was wrong or improper. Your decision as to the charge must be unanimous, meaning that all 12 deliberating jurors must agree. You will receive one verdict slip. When all 12 jurors agree on the verdict, the foreperson should check off that verdict and then sign and date the slip, verdict slip. In a little while, I'll go over that verdict slip a little bit more. For the charge, if you all agree that the Commonwealth has proved every element of murder beyond a reasonable doubt, then you should find that Mr. Walsh is guilty. On the other hand, if you all agree that the Commonwealth did not prove one or more of the elements of murder beyond a reasonable doubt, then the verdict must be not guilty. Let me talk about your roles. Jurors, you have the most important role in this trial because you will decide who and what to believe and whether the Commonwealth has proved Mr. Walsh's guilt beyond a reasonable doubt. You must be completely fair and impartial and unbiased in your work as jurors. Do not let your emotions, any kind of prejudice, or your personal likes or dislikes influence you in any way. Consider the evidence calmly and carefully. Do not be influenced by the nature of the charge or the possible consequences of your verdict. And do not let your personal feelings about any person, criminal charge, or anything else influence your decision. All parties who come before the court stand as equals before the bar of justice. That a case is brought in the name of the Commonwealth does not entitle the prosecutor to any special consideration. Your verdict must be based on the law as I have given it to you, and on the evidence and the facts as you find, and nothing else. By contrast, my job as the judge is to impose sentence if the defendant is found guilty. Therefore, you are not to consider the sentencing consequences of your verdict at all. That's not your responsibility. So please put any issues about sentencing out of your mind. Let me next talk about evaluating the evidence. You must decide this case based only on the evidence that was presented at trial. You may not decide this case based on anything else. Do not consider anything you have read, heard, or seen outside of this courtroom. Those things are not evidence. And you may not base your verdict on guesswork, speculation, or suspicion. Let me talk to the important topic of the defendant not testifying. As you know, Mr. Walsh did not testify in this case. You may not hold that against him. Mr. Walsh has an absolute right not to testify because, as I've explained, he is presumed to be innocent and does not need to do anything to convince you that he is innocent. It does not matter why Mr. Walsh did not testify. It's not relevant to what you must decide, which is whether the Commonwealth has proved, based on the evidence presented at trial, that Mr. Walsh is guilty beyond a reasonable doubt. The fact that Mr. Walsh did not testify is not evidence. You may not consider it or even discuss it in deciding this case. Let me next talk about witness credibility. During this trial, you've heard from a variety of witnesses. With reference to any and all witnesses who have testified before you, you have wide latitude. As a jury, you can believe every single word that a witness says on the witness stand, or you can disbelieve every single word that a witness says on the witness stand. You may decide to accept parts of a witness's testimony and to reject other parts of his or her testimony. That's for you and you alone to decide. If there are any conflicts in the testimony, it is your function to resolve that conflict and to determine where the truth lies. In evaluating the credibility of witnesses, you may use various tools. You may consider the ability, the opportunity, and the reliability of the witness to see or hear something in the past, and then remember and later testify about it before you in this courtroom. You may consider the conduct of the witness, his or her manner of testifying before you, any inconsistency you may have found in the witness's testimony, any interest the witness may have in the outcome of the proceedings, any bias or prejudice or hostility the witness may have demonstrated while testifying before you, the level of accuracy of the witnesses testifying before you, and the reliability of the testimony as it developed before you. These are some of the tools that you have at your disposal to resolve disputed issues of fact in this case. There's one more point about witnesses that I'd like to specifically address, and that's expert witnesses. This term refers to witnesses who have specialized training or experience in a particular field, generally in cases that are tried in our courts, both civil and criminal. Witnesses may testify to facts that are within their own personal knowledge. That is, things they've personally seen or heard or felt. However, in a variety of cases, this one included, issues arise that are beyond the experience of laypersons. In those types of cases, we allow a person with specialized training or experience, call them expert witnesses, to testify not only to the facts, but to their opinions, the reasons for his or her opinions on issues that are within the witness's field of expertise and are relevant and material to the case. Because a particular witness has specialized training and experience in a field, doesn't put that witness on any higher level than any other witness. And you are to treat the expert witnesses just like you would treat any other witness. In other words, as with the other witnesses, it's completely up to you to decide whether you accept the testimony of the expert witnesses, including the opinions that those witnesses gave. also entirely up to you to decide whether you accept the facts relied on by the expert and to decide what conclusions, if any, you draw from the expert's testimony. You are free to reject the testimony and opinion of such witness in whole or in part if you determine that the witness's opinion not based on sufficient education and experience, or that the testimony of the witness was motivated by some bias or interest in the case. You must also, as has been explained, keep firmly in mind, jurors, that you alone decide the facts. If you conclude that an expert witness's opinion, not based on the facts as you find those facts to be, then you may reject the testimony and opinion of the expert in whole or in part. You must remember, jurors, that expert witnesses don't decide cases, juries do. In the last analysis, an expert witness is just like any other witness, in a sense that you alone make the judgment about how much credibility and weight to give the expert's testimony and what conclusions you draw from that testimony. Let me next talk about graphic photographs. The Commonwealth has introduced certain photographs showing items taken from various trash bags retrieved from 300 4th Street, Peabody, during the investigation of this case. You will have those photographs with you during your deliberations, as all the evidence will be with you during the deliberations. Some of those photos, as you've seen, are not pleasant. Indeed, some may be described as graphic. I instruct you that your verdict must not in any way be influenced by the fact that these photographs may be unpleasant or graphic. The defendant is entitled to a verdict based solely on the evidence and not one based on pity or sympathy for the deceased, which might be occasioned by those photographs. Related to this, sometimes evidence is presented that produces in jurors an emotional response. For example, it is natural and understandable to feel sympathy and empathy when you hear or see testimony that suggests what might have occurred to Anna Walsh's body after her death. But as jurors who have taken an oath to follow the law, I instruct you that you must separate any emotional response or reaction on your part from the informational value and weight of the evidence. You must not be influenced in any way by the nature of some of the testimony and video evidence. You must find the facts in this case based only on the evidence. You can't find facts or base your decision, again, on sympathy, anger, passion, or prejudice, or pity for or against either side in this case. Rather, again, jurors, your verdict must be based solely on the evidence in this case and my instructions on the law. So what is evidence? I told you earlier that repeatedly that you must decide this case based only on the evidence presented at trial. The evidence consists of the testimony of the witnesses, as you recall it, the things that were marked as exhibits, and the stipulations, or I told you those agreements of the parties, which I read into evidence. You will have the exhibits with you in the jury room. Things that were marked for identification aren't exhibits, so don't be looking for those, because they're not exhibits, and you won't be able to consider. Other things that are not evidence, and you may not consider when deciding this case, are as follows. The fact that the defendant had been indicted and charged with a crime, not evidence. Questions that the lawyer asked of a witness are not evidence. Only the answers given are evidence. For example, if a lawyer asked, wasn't it raining outside? And the witness answered no, or said, well, it was cloudy. The question is not evidence that it was raining. If a lawyer asked a question and I sustained an objection and therefore the witness didn't answer it, and neither the question nor the fact that the witness did not answer is evidence. I struck or told you to disregard any part or all of an answer by a witness, then the part of the testimony that was struck, not evidence. You may not consider it. Anything that you may have seen or heard when court wasn't in session isn't evidence. The opening statements and closing arguments of the lawyers are not evidence. And if your memory of the testimony differs from what the attorney said in their closing arguments, you should rely on your memory. Any notes that you've taken, they're not evidence, but you may use your notes to refresh your memory of the evidence. As you know, evidence can come in many forms. It can be testimony about what someone saw or heard or smelled or felt. It can be someone's opinion, and it can be an exhibit. Whether the evidence is direct or circumstantial, sometimes we call that indirect, the Commonwealth must prove the defendant's guilt beyond reasonable doubt from all of the evidence in the case. Some evidence proves a fact correctly. For example, if a witness testifies that she saw and felt it raining outside before she came into the courthouse, then that's direct evidence it was raining. Some evidence proves a fact indirectly, circumstantially. For example, let's say a witness testifies that he saw someone come into the courthouse wearing a wet raincoat and shaking water off of an umbrella. That's indirect evidence. That, if you believe it, might lead you to conclude that it was raining outside, even though the witness did not see, hear, or feel the rain. This kind of indirect evidence does not directly prove something is true, but it is evidence from which you could logically conclude that it is. We call this drawing an inference. We all draw inferences every day. We take some known information, we apply our intelligence and common sense, then we reach a conclusion. But inferences must be based on facts. They can't just be guesses that you make when you're not sure about something. Sometimes you can draw more than one inference. Also, you may draw an inference even if it is not necessary or inescapable, so long as it's reasonable and warranted by the evidence. You have to decide, jurors, which inferences are reasonable and decide which seems more reasonable to you. It makes no difference whether evidence is direct or indirect. Commonwealth may be able to prove a criminal charge with direct evidence, indirect or circumstantial evidence, or a combination of both. Let me next talk about credibility. An important part of your job as jurors is to decide who and what to believe. You may believe everything a witness says, part of it or none of it. Sometimes people do not tell the truth. You must decide whether a witness was being truthful or deliberately lying. If you conclude that a witness lied to you about something, then of course, you should not believe that part of the testimony. Sometimes people make an honest mistake. You must also decide whether a witness testified accurately or whether the witness may have gotten something wrong without meaning to do so. A witness may recall seeing or hearing something, but actually be mistaken. For example, the witness might not have paid close attention or might have misunderstood what was happening. Or a witness's memory of what happened could be incorrect. If you conclude that a witness tried to be truthful, but that some part of that person's testimony was inaccurate, then you should not consider the inaccurate portion. How do you decide whether you believe a particular statement by a particular witness? Well, ask yourself. The testimony seemed reasonable or probable. Did the witness have a good chance to observe what happened? How much attention did the witness pay? Did the witness's memory seem accurate? Was the witness's testimony consistent with other evidence, or instead contradicted by other evidence? How did the witness behave and answer questions while on the witness stand? Did the witness have any motive for testifying in a certain way, or have any other bias that may have influenced the witness's testimony? You should evaluate the testimony of a police officer or someone else who works for a law enforcement agency in the same way as you would evaluate anyone else's testimony. You must not automatically believe or automatically disbelieve a witness just because a person is a police officer. Moving next to the importance or significance of evidence. It's up to you, jurors, to decide how important each part of the evidence is, whether it's testimony by a witness or an exhibit, whether evidence is direct or indirect. You should give each piece of evidence whatever significance you think it deserves. You're not required to believe something simply because it appears in an exhibit. It's up to you to decide how important any exhibit is. You do not have to treat testimony by a witness as more or less significant than the exhibits. You may find that a witness's testimony is very important, or that an exhibit is more important. That is up to you. Next, I want to talk about the alleged victim's state of mind. You heard evidence of statements Anna Walsh allegedly made to William Fausto, Jem Blublue, and Alyssa Kirby. Those statements are admissible for the limited purpose of establishing Anna Walsh's state of mind, as may be relevant to the defendant's motive or intent to kill. Those statements cannot be considered as proof of the criminal acts charged or as proof that the defendant had a bad character or a propensity to commit any criminal offense. Let me next talk about motive. First, motive is not an element of the offense of murder, and the Commonwealth is not required to prove or show motive. Evidence of motive can be relevant to the issue of intent. Second, an absence of evidence of motive may tend to raise a reasonable doubt. Third, even a total lack of evidence of motive would not necessarily raise a reasonable doubt as to the guilt of a defendant, so long as there is other evidence produced that is sufficient to prove the guilt beyond a reasonable doubt. Let me now move to the area of something called consciousness of guilt. I spoke earlier about inferences and the drawing of inferences from indirect or circumstantial evidence. At this point, I want to talk about a particular type of inference based on a legal doctrine called consciousness of guilt. In the course of the trial, there was some evidence suggesting that the defendant may have intentionally made certain false statements before his arrest, and that he may have taken steps to conceal Anna Walsh's body after her death. I want to stress to you that I'm not suggesting that he did so, or that you should find that he did so, but only pointing out that there was evidence to that effect. It's up to you to decide what evidence to accept or reject, and what facts to find from the evidence. I point to that evidence to illustrate the legal point involved. If you find from the evidence that the Commonwealth has proved that the defendant provided false information to the police and or took steps to conceal the body of Anna Walsh after her death, then you are permitted to consider whether such actions indicate feelings of guilt by the defendant, and whether in turn such feelings of guilt might tend to show actual guilt on the charge. You are not required to draw such inferences, and you should exercise great caution, and do not do so unless they appear to be reasonable in light of all the circumstances in this case. You should always remember that there may be numerous reasons why an innocent person might do such things. Such conduct does not necessarily reflect feelings of guilt. Please also bear in mind that a person having feelings of guilt is not necessarily guilty in fact, or such feelings are sometimes found in innocent people. If you decide that such inferences are reasonable, it's up to you to say how much importance to give them. But remember that such evidence is never enough by itself to convict a person of a crime. You may not find a defendant guilty based upon such evidence alone, but you may consider it along with all of the other evidence in this case. Next, I want to speak to impeachment by the defendant's prior or subsequent bad acts. The only charge the defendant is now facing is the charge of murder. You have heard mention of other acts allegedly done by the defendant, namely, that he was charged in 2018 and sentenced in 2024 in a federal case involving art fraud, and or that he lied to the police, and or that he disposed of the body of Anna Walsh, and or that he lied to his federal probation officer. You may not take the defendant's prior or subsequent acts as a substitute for proof that he committed the crime charged, nor may you consider them as proof the defendant has a criminal personality or bad character. You may consider this evidence solely on the limited purpose of the motive, state of mind, intent, plan, or absence of mistake or accident on the part of the defendant. You may not consider this evidence for any other purpose. Specifically, you may not use it to conclude that if the defendant committed these other bad acts, that he must have also committed murder. It would be extremely unfair to consider this evidence for those purposes. Moving next to your notes. Many of you have taken notes during this trial. Your notes may help you remember the evidence, especially the testimony, but of course they're not an actual transcript or official recording of what was said. So use your notes only to help you remember what you saw and heard in the trial. Whether you took notes or you did not, you must rely on your own memory of what the witnesses told you. After the trial is over and you've returned your unanimous verdict, the court officer will collect your notes and I will order that they be destroyed. During the trial, the lawyers occasionally, as was appropriate, objected to questions posed by the witnesses. They may have asked to strike something or in essence erase something you saw or heard. When a lawyer believes that something would violate those rules of evidence we talked about from the beginning, that's the only way they have to let me know. And so don't hold it any against the lawyers that they made such objections. It's part of their job. I want to next turn to fairness. Each of you has taken an oath and promised to be fair, and I'm sure you want to be fair, but that's not always easy. Part of being fair is being willing to examine your decision-making process to be sure that you base your decisions as jurors only on the evidence and the law. One difficulty comes from our own built-in expectations and assumptions, and they exist even if we're not aware of them. We all have them simply because we're human beings. They affect our actions and decisions without us even realizing it. As a judge, I have the same problem as everyone else. So let me share a few strategies that I found to be useful. These strategies will help you make sure that you decide this case based, again, only on a careful examination of the evidence and on the legal rules that I'm teaching to you. First, slow down. Do not rush to a decision. Take time to consider all of the evidence. Quick decisions are more likely to reflect stereotypes or assumptions about people that we might not even be aware of. Second, as you start to draw conclusions, consider not only the evidence that supports your conclusions, but also think carefully about any evidence that undermines or weakens those conclusions. Third, as you think about the people involved in this case, ask yourself, would my decision be different if the people were different? For example, what if the people involved were from different social or economic groups, or different ages, genders, gender identities, or sexual orientations, or came from a different racial or ethnic background? Fourth, listen to each other. Other jurors may have different points of view. If so, they may help you make sure you're focusing on the facts. Of course, other jurors could be influenced by their own unstated assumptions. So don't hesitate to share your views. You should participate actively, particularly if you think other jurors are overlooking or undervaluing evidence that you think is important. When you explain your thoughts to your fellow jurors, you help everyone focus on the evidence. If you do these things, then you'll play your part in reaching a decision that's as fair as is humanly possible. And that's your obligation as jurors. Now I'm going to move to giving you some instructions about how to conduct your deliberations. Privacy. The first point you need to know is that you must keep your deliberations secret. You should not tell anyone outside of the courtroom, not even me, anything about your deliberations. For example, please do not tell me or anyone else the results of any votes that you may have taken before you all agree on a unanimous verdict. You must not tell anyone about how your discussions are going or what other jurors are saying. If you need to communicate with me before you reach a unanimous verdict, you should send me a written note in a form that you all agree on. The court officers have it. It must be signed by your foreperson, and I will discuss your note with the lawyers, and then I will either send you a response in writing, more likely, or bring you into the courtroom, less likely, and respond to you in person. If you do send me a note, do not mention any votes that you have taken or anything else about your deliberations. Do not talk about this case unless all of you are present and no one else is in the room. If one of you needs to leave, even for a moment, the rest of you should stop deliberating until that juror returns. That includes the bathroom breaks, because I know that's right inside your spot. If we break for the day without you reaching a unanimous verdict, you must not communicate with the other jurors about this case until the next day, only after we gather in the courtroom, and I ask you to resume your deliberations. As you work to decide this case and until I accept your verdict, you must not communicate with anyone else about the case except each other. And you must not do any kind of research about this case. You may not do so in any way, including with electronic devices, a cell phone or a tablet. This also will apply to the ultimate jurors. We'll talk about those alternate jurors. The law permits only 12 jurors to participate deciding a criminal case. There are 16 of you here. So in a few moments, our clerk is going to randomly select 4 of you to be what we call alternate jurors. The other 12 of you will work together to decide this case. We chose 16 of you originally in the case, just in case one or more of you got sick or needed or had some other unexpected emergency. If you are chosen as an alternate, your continuing service is still very important, and you must comply with all the rules that I placed on you. The alternate jurors will stay in another room, and you can't have your own private deliberation. You can't discuss the case with each other or with anyone else for obvious reasons. If we lose a deliberating juror in the group of 12 because of some personal emergency or sickness, then I will send one of the alternates into the jury room. If this happens, the deliberating jury will have to restart its discussions from the beginning. One of you is going to serve as the foreperson of this jury, and we will discuss who that foreperson is going to be in a moment. Foreperson will make sure that each of you has the chance to speak and that the other jurors listen to you respectfully. But the foreperson's opinion about the case is no more important than the opinion of all of the other jurors. Once you agree on a verdict, the foreperson will fill out the verdict slip and will report your verdict in court. I want to next talk about making decisions as a group. When you work together as a jury, you will be making decisions as a group. This kind of decision making is very valuable. Why do I say that? When a jury hears and sees evidence, each juror acts as a safeguard for the others. For example, someone else may recall evidence that you missed, and each of you will have insights that will help the other jurors make sense of the evidence and reach a verdict. No member of the jury is more or less qualified than any other juror to decide who and what to believe. You all heard the same evidence, listened to the same witnesses, and looked at the same exhibits. And you have all taken the same oath, promising that you will, well and truly, try the issues between the Commonwealth and the defendant according to the evidence and the law. So, you are all equally qualified to reach a verdict. I have a few more suggestions that might help you work better together. First, you should discuss and analyze the evidence before you take any votes about a verdict. Voting first could keep you from discussing the issues and hearing other people's perspectives before making up your own mind. Second, I encourage you to discuss not only the evidence you think supports your view of the case, but also what evidence you think might lead you to make a different decision. Third, as jurors, and as the other jurors talk about the evidence that they found important, listen. In order for this process to work fairly, each of you should hear every other juror's insights and ideas. Please be open to them, since they might influence your own thinking. Fourth, don't be shy. As in any group, some of you may feel more comfortable than others sharing your thoughts, but you must have the benefit of everyone's input to help you reach a just verdict. For example, you may be the only one that remembers a particular piece of evidence or has a particular point of view. The more points of view that you all hear, the more effective your deliberations will be. Fifth, don't be afraid to change your mind if the discussion persuades you that you should. But you should not accept a decision just because other jurors think it's the right one. In the end, you should vote based on your own assessment of the evidence, regardless of how other jurors have voted. Ultimately, jurors, each of you must decide this case for yourselves. One last pause to consult the attorneys. So I talked to you about a foreperson, and I talked to you about what we call reducing the jury. That is, reducing you down from 16 to 12. I'm appointing juror number 138 in seat number 6 as the foreperson of this jury. Our clerk is now going to randomly select 4 of you from among all the jurors except the foreperson to serve as alternate jurors. So what's physically happening is juror number in seat number 6, juror number 138, numbers out of the thank you, Madam Clerk. Madam Clerk.
You are the numbers 1 through 16, with the exception of number 6 of this. You are our first alternate is Jordan C.
The notebook. Solomon.
I Our next alternate is Jordan, seat number 5. Jordan, seat 15. And our last alternate is Jordan, seat number 11.
One last substantive thing that I want to go over with you jurors before I really get into finally the concluding remarks, and that is I said to you earlier in this second part of the charge that I would go over the verdict slip. There is a verdict slip, and I know that you can't, unless you have stellar vision, you can't see it from where you are, but you can get the layout of it. I'll read it to you. The verdict slip reads, count 001, on or about January 1st, 2023, and it puts the charge, murder in the first degree with deliberate premeditation. That is the charge. We, the jury, find the defendant, and there are 3 options. Not guilty, guilty as charged, murder in the first degree, guilty of murder in the second degree. And there's a place to sign it and date it. And again, the 4-person in pen, not pencil. This time, Madam Clerk, I'm going to ask you to swear in the 4 officers.
Do you solemnly swear or affirm that you will take charge of this jury, keep them in some secluded places where they be? You shall not speak to them or suffer anyone else to speak to them except in order of the court would ask that they be. Say no.
So now the deliberating jurors, the 12 of you, are going to go and start with private discussions. Have confidence in what you are about to do. By serving on this jury, you carry out a long and proud tradition of citizens of the Commonwealth of Massachusetts serving on jury trials and deciding criminal cases. If you are honest, thoughtful, and fair, you will be able to reach a fair and just verdict dictated by your logic, without bias, without prejudice or sympathy, and not prompted by any facts except those that you've heard here in the courtroom during this trial. All we expect from you jurors is that you decide this case with integrity and principle. And with that, I'll ask you and let you go back to the deliberation room to begin your work. Thank you very much.
Court, all right, please. Take your notebooks with you and follow me.
So I will, as I said, put this on the bench, there's some small edits necessary to back. You may see some small edits that I need to make to the instruction, and I'll make those now, take the draft off, make sure the numbers are all right for the index. For those down. Anything else that the parties need to bring my attention before I get there?
We received materials to secure those items, and we're going to work
Oh,
on
can I
that.
see that? Are they secured yet, or you're going to?
We're going to secure them. I haven't had the opportunity yet.
All right, let Madam Clerk know when that's done, so I just want to take a look at those before they go in. And of course, our court staff as well, for us, take a look at those, make sure that they're comfortable with what's on the paper.
And we thought we'd cut up pieces of parchment paper for the jurors to need to examine anything that they can place on the table.
You have a role they can do it themselves.
We have a roll. We can give them scissors if you want.
Well,
I think that's why I put that out there.
right.
Thank you.
I think you're pretty familiar that I have a 10-minute rule. Which means at all times, Madam Clerk, to be the whole meeting to be able to return to the court within 10 minutes, right? I won't take it further than the hours of 1 to 2 on any day. The time to attend to your other work.
Thank you, Ron.
All rise.
During those conversations and your observations, Anna told you that Brian wasn't the jealous type.
That's correct.
And at some point, while Anna was working for you, she confessed that she had a crush on you.
She said that, yeah, maybe.
I think you've already kind of said it, but Mr. Walsh was never jealous of your relationship with Anna.
I don't believe so.
Oh, Jim, he was the boss. of Anna and friend. They worked together for years before she got this great new job. And he was there with Brian and Anna the last day anybody saw her alive. That was New Year's Eve, and they celebrated the end of the year. You can see the verdict clock is now on our screen. The jury has just been given the case 3 minutes ago, so they're just getting settled in the deliberation room. We're still picking up the rest of the closing arguments right now from the Commonwealth. Anna's husband, Brian, of course, is facing first-degree murder. If he is found guilty, he'll spend the rest of his life in prison. He's hoping beyond hope that somehow this jury believes the story that he just found his wife dead and didn't know what to do and decided that his best course of action was not to tell anybody, not to call 911, not to try to revive her, but to chop her up and get rid of her body. Let's go in, watch the end of the Commonwealth's closing argument.
But it's not there. He went to CVS to buy hydrogen peroxide, and then he went to Stop and Shop to buy ammonia. No wonder the house was so clean. And on Monday, January 2nd, he went to Home Goods for rugs and candles. And then he went to Home Depot, where he bought buckets with lids this time, baking soda, and a hatchet. And at some point that day, he got a call from his probation officer, and he lied, and he said that he was picking up his children. He was able to calmly speak with her. No panic. He had everything now that he needed to dismember the woman that he supposedly loved. And he started to take her body and to throw it in the dumpster, because he had to cover up the crime to get rid of the evidence of the murder. This was not a man in crisis. This was a man who on January 4th went to TJ Maxx to buy pants with the store exchange card. He was humble. But Alyssa Kirby texted him on January 4th asking about Anna, and so he called Tishman Spire a few minutes later and started to pretend to look for her. He called Will Fastel, but he didn't leave a message. He called back later, and then he calmly left the voicemail. Okay. The defendant knew where Anna was. The defendant even texted Anna's sister in Canada and said that she was missing. He was methodical. Look at the text messages. And at 4:30 p.m. on January 4th, the defendant went to Lowe's to buy a trash can. Comfortable. Not comfortable. The police were coming to the house and talked about Anna. And the defendant had the house ready. The police think his wife is in D.C. He had his phone records ready, and he sent text messages to Anna, even though he knew she would never see him. Despite everything that he had done, on January 2nd, the defendant wrote a text message to Anna. I still love you. Ha ha. Ms. June. The defendant prevented anyone from ever finding Anna's body and did no autopsy. Dr. Atkinson told you that the medical examiner can't do an autopsy of our body, and all that remains of Anna are 2 hairs, some blood, and a few things that belong to her. A part of a necklace she often wore, her hunter boots, a black jacket, a purse, her credit card, and a few other items in the dumpster, his mother's apartment complex. The defendant searched his MacBook. For a murder conviction didn't happen. Please do not allow the defendant's self-serving act of dismembering and disposing of Anna's body to let him get away with this murder. At the start of this trial, we asked you to use your common sense. And when you do that, when you analyze the evidence, set your deliberate, and continue to use your common sense, you will see that the evidence shows there is only one verdict. Find the defendant who is guilty of the premeditated first-degree murder of Anna Walsh.
All right, that's the end of the Commonwealth's closing argument. It was subdued, especially when you compare it to the defense close from Larry Tipton, who was very passionate. And what he was saying, maybe people didn't agree with, but how he said it, I mean, I think he grabbed the attention definitely of the jury. They have the case, 8 minutes and counting. Josh Schiffer, Philip DeBay still with us. Josh, the subdued, she didn't need to, you said it last time, she really didn't need to do anything more than she did. Like, just be calm and read her paper and get those people back into the room.
The sale was already really made during the trial. The state got up, presented a whole bunch of evidence. The defense said, "Hey, we're gonna answer this," and we all watched. There wasn't a lot of answer. So then, in summation, the state has its opportunity to just say, "Hey, y'all, look at what this is." And Ted, you referenced earlier, kind of the wink and just go do your. That's really what I think the state almost could have done more of. Is, "Hey, y'all, you know what we're here to do. You haven't heard any reason not to follow the request of the state to do your job as jurors and issue a conviction, because there's not any evidence that contradicts our allegations."
I loved, Philip, the one thing the prosecutor said was, you know, you look at those internet searches for what they are and read them, and those are powerful. But then the searches that he didn't make? Like, how do people just drop dead? And has a wife ever just laid there dead? And what do I do? None of that. He's not curious in terms of how she died at all. And Mr. Google wasn't interested there. Your overall thoughts on this case and where it's going to end up?
Well, I thought the defense was going to put on more or some evidence to explain how she could have died. Because remember, during the defense cross-examination of a couple of the witnesses, they were alluding to her dying of Legionnaire's disease. I thought, oh, goody, we're going to get a real natural cause of death here. They're going to put on somebody who worked on their HVAC heating and air conditioning system and found a breeding ground of Legionella bacteria that could be deadly in the workplace. Nothing. Instead, all they did was just sort of float the idea as a kernel of doubt, which is okay. I understand that. But to seasoned defense lawyers and to seasoned courties, it looks like you couldn't find anybody to come on and testify to that fact. The one criticism I do have of her, I just think that her delivery, given all the salient facts that she has pointing toward guilt, was just a little too sing-songy. And I mean, if we're really honest, I mean, even as Josh, you could have given this case to a first-year DA. You don't even, I mean, this is a classic type case you'd want to cherry pick because you know it's a dead bang winner. But sometimes, even with the winning cases, if you don't have the right delivery, you put your jury to sleep and then they listen more to the defense. So I don't think this is going to be a straight up not guilty, but it would not surprise me in the least if this deadlocks.
Interesting. And that would be a massive loss, Josh. There would be some memos thrown around in the DA's office.
I would say that, and I unfortunately kind of agree with Phil that there is that outstanding chance because the state, as great a job as they did, could have done better, could have wrapped it up smoother, cleaner, tighter. I understand that they let him plead to the lesser charges in order to try to steal some thunder. There was some big time strategery involved in what facts were going to come out. But you just saw the state talk about the fact that he was on monitoring. It doesn't take too much to get into the fact that the jury's going to know about some of the prior issues that were causing marital stress, which is the motive that since they don't have the details, the fantasy minds of jurors can go all over the place. And without telling them exactly what's up, they could really extrapolate into some fantastic motivations. State played that very, very well because the jury knows that there were problems. Without an expert coming for the defense to testify, yes, the HVAC, breeding, Legionnaires, like Philip's saying, that's how you defend this case.
Or even someone that says people die, or someone that says, this phenomenon that sounds ludicrous does happen. Is it rare?
And
absolutely, yes.
Yeah, you needed an expert.
Yeah, absolutely. Yes. Is this case, Philip, almost freeing as a public defender in LA? You have been up against some cases over your time that were just you were the absolute underdog. Does it free you as a litigator, like where we saw with Tipton? It's like, all right, we're going to lose, but I'm going to go all in. And because it feels as though the Commonwealth is a little tight, like they're the favorite in a football game, and they just don't want to lose to this bad team. And Tipton, on the other hand, is just letting it fly.
Well, I think a lot of it has to do with the delivery, because on paper, cases for the prosecution can really seem to be airtight, impenetrable, but it's all in the presentation. I mean, the whole thing could really fall apart in front of a jury. And even when you do present it all, if you do not have the right manner in your presentation, then it can just sort of collapse and crumble right in front of a jury. And I've seen that happen. And not just at trials, I've seen it at preliminary hearings where they put a baby DA on the case and they just screw it up. They don't know how to mark exhibits. They don't know how to introduce evidence, and they don't know how to argue it. So I think a lot of it really just depends on the caliber and the quality of the attorney trying and defending the case. That's just my opinion. And one other thought, and that is I truly believe that there was a reason why the body was chopped up in the manner in which it was. I think in order to normalize what had happened, the body had to go into sort of like hefty bags, so it wasn't looking like he was lugging something large, like a Foot Locker or something even bigger, where you could automatically assume that somebody is carrying a body out of the house because nobody has seen or heard from Anna in all this time. But when you do it in little bags, in small, little hefty containers, it sort of normalizes the criminal aspect of trying to get the job done. So I think that's why it was done in that manner.
I mean, Josh, there's a very good chance that they get back in that jury room, they all look at each other and say, do you want to eat lunch first or just head back and deliver the news?
And really, for Mr. Tipton, just to touch on something Phil was talking about, fail hard. That's what my lawyer tells me. If you know that you're facing the uphill, you don't want to incrementally attack and take a tedious, trepidatious approach. No, swing hard, fail hard, go down swinging. That's what a good lawyer does, and I really appreciate Mr. Tipton really swinging like that.
Yeah. All right. We'll get a break at 16 minutes and counting. The jury has had this case just getting underway, picking a four-person, and then who knows how long it's going to take. But we'll be here waiting. There's the live look inside that Dedham, Massachusetts courthouse. We're used to the Cameron Reed fan. Well, this is the Brian Walsh clock. It's ticking.
The disappearance of mother Anna Walsh.
Her husband now charged with her murder.
All eyes on this accused killer.
Mr. Walsh was suspecting his wife of having an affair.
Massive trail of evidence.
This incredible timeline of Google searches.
It shows everything that was in his mind. He searched how long before a body starts to smell.
The disappearance of Anna Walsh murder trial. Live coverage today on Court TV.
to Dedham. You first, Philip, I want to talk about a couple of the key witnesses in this case, and one of them was this Jim guy. He was the former boss. He was there on the New Year's Eve. He was there during this celebration, and he said that there were a couple things that came out of his testimony. One was that he said Brian Walsh is not a jealous guy because she had a crush on me, and he knew that she had a crush on the guy that she was actually having an affair with. And no, he was not a jealous person. He was okay with it. The other thing he talked about, though, was that he was told by Anna that the marriage was having trouble. Let's listen to Jim on the stand and then talk about it.
What did she tell you about her life at the time?
That what I got from it was that there were some issues, marital issues included. And and that I told her, I said, I don't want you to be too strong. Have you considered therapy? And she said yes.
Okay. What is your memory of what she said as far as marital issues? And not your feeling, but what you remember the conversation to be, sir.
Sure. Part of it was that she was going back and forth from DC, which was taking a toll on her. And the fact that that Brian had not been able to leave Massachusetts, so the children were here. And that was a huge burden on her psyche.
Philip, how effective was this witness for the Commonwealth?
To be honest with you, I thought it actually helped the defense because she's not saying stuff like, he's just too boisterous. I don't like the way he talks to me. I don't like the way he treats the children. He talks down to me. He's got a drug problem. He's spending all of our money. Instead, it's basically a forlorn spouse living in sort of multi-employment states. You're bobbing back and forth from Massachusetts to DC. He doesn't want to move to DC. Well, that's not saying that there's an inherent character flaw or some type of personality in Brian Walsh. It's just saying that she's lonely and she wishes that they could be together. It would be one thing if she would have said, I want out. I want a divorce. I don't love him anymore. He doesn't love me. We've grown apart. Love is on the rocks. He doesn't bring me flowers anymore, kind of thing. But we're not hearing it. And this is a classic situation when you have like bi-coastal relationships or couples and other partners who are just living apart. So I don't really think that he really moved the needle in favor of the Commonwealth. Okay. And there was one other note. I took issue, and I don't know if Josh agrees, with this whole line of testimony even coming in. Because if you really think about it, I think the prosecution was offering it to prove the state of mind of Anna. Well, it's classic hearsay in that regard for two reasons. Number one, Anna's state of mind is not even relevant. If anything, one of the elements of murder is malice aforethought, meaning an intent to kill on the part of Brian Walsh. So I don't even know how Anna Walsh's state of mind is even relevant. But even beyond that, it is classic hearsay because it's testimonial in nature. And I don't think it's strong enough to get around the hearsay rules to show some type of motive, because here the motive is not even present. Again, it's not as if there were discussions about parting because of money or other problems.
Right. Josh, we should note that Brian couldn't go to D.C. because he had the federal case against him, and he was locked in Massachusetts. Your thoughts, Josh?
So Jim was one of my top 5 witnesses of 2025. I thought that he was absolutely fantastic. Besides the fact that I just think he's an interesting fellow that is the kind of person I like to hang out with, I think his honesty and authenticity was rock solid. I don't really wanted to be there, and I believe the Commonwealth called him in order to prevent the defense from calling him. And they stole some of the defense's thunder because, just like Philip's talking about, the testimony was very beneficial for the defense when it comes to really filling out a bunch of things that the state didn't want to be emphasized. And that's because Jim was honest. And notice, when you listen to a witness like that answering the questions, he takes his time, he's thoughtful, he's fair, he doesn't want to say the wrong thing, and he wants to be really accurate. That is the best kind of witness. And he's just engaging, and you want to hear from him. The Commonwealth did get a couple solid points in, but I'm kind of with Philip where the defense made some of its best intrusions into the state's theory through Jim.
Yeah. And, he kind of looks like Sean Connery, so there's no...
Oh, God, love it.
It was great. I agree. He was interesting. You just watched him and listened to his manner. The whole thing was great. Let's get a break. We'll have more. We're waiting for anything out of that courtroom. Plus, University of Michigan's head coach. That's next. Potential charges that he is facing in terms of seriousness and what kind of situation he's in.
Well, I'm not buying the home invasion aspect of it, Ted, and here's why. Typically, we associate home invasion with basically a form of residential robbery. And robbery really means is that you're taking property from somebody else by force or threat of force, as opposed to just barging in, wanting to have a discussion. If you're barging in to want to hit somebody, who knows, maybe even stab them or engage in some type of assaultive conduct, that's a form of burglary. Entering a home to either steal or to commit a felony is the textbook definition of residential burglary. Now, given that, it still doesn't give him a pass to go over there and do that. I mean, if anything, he's supposed to set an example. But given the relationship that he had with this young staffer, he probably figured he could just go over there and throw his weight and his might around, and she would just kiss the ring to keep her job. Well, she did this to the wrong person, and obviously her family was there and called the cops. So it's not looking good for him, and he's going down.
Okay, the judge is just taking the bench here, and I believe we have audio, so let's listen in.
We are now calling case number 25F12175. This is the people of the state of Michigan versus Sharon Banfield Moore. Mr. Simon. Here's.
Thank you, Your Honor. Good afternoon. Katie Rosmersky, First Assistant Prosecutor for the Special Victims Unit for the people.
Your Honor, Joe Simon on behalf of Mr. Moore.
That's the charges, sir.
We waive formal reading of the complaint. Your Honor, stand to the charges.
Formal reading having been waived, the will be entered on your client's behalf. Simon, make your bond argument now or reserve?
Your Honor, I think the people want to make a presentation. I'll go after that. That's okay.
All right, Mr. Rosmersky.
Your Honor, thank you very much. I appreciate that. Mr. Simon. And thank you for the opportunity to be heard. As the court is well aware, this is not a series of offenses in Michigan that allow you to deny bond. We're certainly not asking for that. This is a felony of home invasion third degree, misdemeanor stalking, and misdemeanor entry without permission. Your Honor, we are asking for a $25,000 cash or surety bond in light of the fact that we cannot ask for you to deny bond. I get that he's a man of means, and so this is a bit of a nominal monetary ask, but quite frankly, it would be an ask that I would make for any defendant charged with these offenses before you. So what strikes me as perhaps more important in this scenario are conditions that I would like to ask for, because of course, as you know, Your Honor, you're tasked with trying to make sure that he reappears, but also the safety of the public and this victim in particular. So Judge, in addition to an ask for a $25,000 cash or surety, we are asking, should you post that? Should you impose that? We are asking that you order that he undergo a mental health evaluation. We are asking that you order him to submit to a GPS tether and that there be a no-go to this victim's residence or place of employment. Ask that you order that there be no contact with her whatsoever in any means, any fashion, direct or indirect, that there be no stalking behavior of any kind, that he be ordered to surrender any and all weapons, further that he be ordered to surrender his passport. Judge, the reason, Your Honor, the reason we make those requests is in light of the factual scenario that gives rise to these charges. My best understanding from a thorough review of the police report and as much body worn camera as I've had an opportunity to review is that I understand that our victim broke up, they had an intimate relationship for a number of years, defendant and victim, that our victim broke up with this defendant on Monday morning early, that there continued to be defendant making numerous phone calls and sending numerous texts from that time moving forward that she did not answer, did not respond to, and did not want, that eventually she presented herself to the University of Michigan, cooperated in some form of investigation there. As we all now know, defendant was at some point on Wednesday afternoon fired from his employment. He then, at some point soon thereafter, came to her apartment in the address that is alleged in the complaint, barged his way into that apartment, immediately then proceeded to a kitchen drawer, grabbed several butter knives and a pair of kitchen scissors, and began to threaten his own life. I'm going to kill myself. I'm going to make you watch. My blood is on your hands. You've ruined my life. And a series of very, very threatening, intimidating, terrifying, quite frankly, statements and behaviors there in that apartment. It was only then, Your Honor, when the victim, she called her attorney and then at some point indicated she was going to call the police, and then he left. And so, Your Honor, while I understand that there isn't evidence to suggest that he directly threatened the victim with any of those implements that I've indicated, the totality of the behavior is highly threatening and highly intimidating. She was terrorized. And in light of the totality of all of those circumstances, we consider the defendant to be a risk to public safety, a risk to this victim, and it's for those reasons that we are asking for those specific conditions. I'm more than happy to answer any other questions that the court may have or give you further information. I appreciate the opportunity. Thank you, Judge.
Mr. Simon, Mr. Bond.
Your Honor, let me start at the end with people in terms of risk to public safety. My client's 39 years old with zero prior criminal history, zero prior contact with the criminal justice system in any fashion. The threat to public safety argument by these charges, maybe that's the point, but there's no evidence to suggest that he's a threat to public safety. The next thing is that the people referenced the corporal that I want to come back to, that we can't deny bond in a situation like this, and they referenced something else that I want to come back to, which is the fact that they reviewed thoroughly. And they referenced something else that I want to come back to, which is the fact that they reviewed thoroughly the police report and they reviewed thoroughly the body cam. I've had none of that opportunity. And that's too early for that in the proceedings. So when people come in and make factual representations, although I trust Ms. Rosmersky very much as an officer of the court, I have no ability to respond to those factual representations. So here's what I'm going to ask the court
The monetary bond component, the two considerations by court are my client will appear. Let me speak to that. He's got a home here. His family is here. He's got ties to our community. He's retained a local counsel here. The second thing is that my client is not otherwise a danger to the public or danger to the complainant. That is why monetary components are requested, but there are other measures to address them. For example, the request for a GPS tether, that was an expected request. My client will gladly comply with that request. The second thing is my client having no contact. Certainly, we have no objection to that order, and my client would be at his own peril if he were to violate that. His bond would be summarily revoked. In terms of surrendering the transport or passport, Your Honor, there's no really indication that he is a flight risk. My client has those established ties that I talked about. But in addition to that, Your Honor, he would have an order from the court like everyone else has. There would be no leaving the state and the country without permission of the court, and he would certainly abide by that. Your Honor, with respect to the request for a mental health evaluation, I will represent a few things that are my understanding, again, without being privileged to have reviewed discovery yet. My understanding is that following his arrest, my client was taken to the St. Joseph Mercy Health System for an evaluation, a mental health evaluation. My understanding is following that evaluation, he was not turned over for a commitment, but instead turned back over to law enforcement for lodging. That's where he's been in Washington County Jail since. I can also tell the court that the community mental health department saw my client yesterday for an evaluation as well without any further recommendation. If you make that a condition of bond, I can tell the court that he goes to a mental health evaluation. He will absolutely comply with all any aftercare recommendation. Lastly, Your Honor, with respect to the bond amount. I forgot to tell you about weapons. He has no weapons, but he'll surrender. If you order that he surrender any weapons that he doesn't have, he'll be glad to comply with that condition. With respect to the bond amount, Your Honor, in a case like this, with charges like this, in a normal circumstance, we'd be requesting a personal recognizance bond and frankly expecting the court to order it. We all know this is not our ordinary circumstance. It's not an insignificant amount of money to anyone. And I ask that the court set the bond amount to the principles, not of my client's bank account, but to the principles of the charges and to the principles of the court rule. Therefore, I'm requesting that if the court orders a monetary component at all, that it be with a $25,000 10% privilege. And also, Your Honor, if my client is to order to a GPS tether, things have to happen pretty significant to try to get that in place in time for what we hope to be service today. Thank you.
Mr. Moore, could you state your name, please?
Jerome Moore.
So you are not to use alcohol, marijuana, or any other controlled substance that is not prescribed to you. You are not to possess or purchase a firearm or any other dangerous weapon. You are not to engage in criminal conduct of any kind whatsoever. You may not leave the state of Michigan without permission of the court. Prior to your release, you'll be placed on a GPS tether. You will not be released before that GPS tether is placed upon you. You must continue all mental health treatment as a condition of your bond. The named victim in this case will not be placed on the record. You may not have contact with that individual. That means no calling, no writing, no video chatting, no texting, no emailing, or any other form of contact the human mind can possibly fathom. No one in the world thinks that this person is going to reach out to you. Should they do so, and again, no one thinks that they're going to, you may not reply in any form or fashion. The named victim's address will not be placed on the record, but you may not go to that location for any reason whatsoever. Are we understood on the no contact and no go to, sir?
Yes, Your Honor.
If you have any questions about that, you have a good attorney, simply ask them. You understand?
Yes, Your Honor.
Bond will be set in the amount of $25,000 cash surety, as requested by the prosecution's office. The court does not determine innocence or guilt. This court determines flight risk and community safety. The court finds with these conditions in place, it has been met. Mr. Simon, we are setting probable cause conference at this time for January 8th due to the holidays and scheduling. Is that a good court date for you?
Your Honor, my client will waive his right to have that next court appearance within 14 days. I discussed that with him. I also try to coordinate calendars with Ms. Wisniewski. In support of that, I think we're both available on January 22nd. The court would order that. And I'll add one more thing for the record in support of that. I understand that there is continuing investigation. So in addition to the discovery I don't yet have, there may be even more. So
it will be January 26th, 2020.
22nd, 29th.
January 22nd. And January 22nd, 2026, 9 a.m., 14A1 District Court, Courtroom C. That will be in person. Sir, do not violate these bond conditions. Follow all orders of the court. Stay in contact with your lawyer. That concludes this hearing.
Thank you very much.
Okay, hearing is over. We'll get a break. We'll talk about what we just watched and what's happened, what will happen next to the former head coach of the University of Michigan, now in a jumpsuit appearing via WebEx from a jail. Plus, Walsh, the jury, almost up to an hour. Stay with us.
The disappearance of Anna Walsh.
Her husband now charged with her murder.
All eyes on this accused killer.
The disappearance of Anna Walsh murder trial. Live coverage today on Court TV.
Tonight on Closing Arguments, Brian Walsh's fate now rests in the hands of 12 jurors. We're live with every development as deliberations get underway.
Closing Arguments with Vinny Politan tonight at 8, 7 Central, only on Court TV.
Of court and counsel is for all of us to get on ahead to having these witnesses testify. However, some information about the evidence in this case is worth mentioning now, and that's what I'm going to do for you. This case is a tragic suicide that was turned into a homicide. Our position is that that was done without a valid reason. On July 18, 2024, I think the court earlier mentioned the date in the PC affidavit as January. That might have been the probable cause for arrest. The incident date that we're talking about is July 18, 2024. Mariah King was at a place called the Going Green Marijuana Dispensary. She was reported there to be intoxicated and paranoid. She had scratch marks on her neck. She told an employee at the store that it was a suicide attempt, which caused those scratches. She said, "I tried to stop myself from breathing." Her mother, Kimberly Lapham, was contacted from the store. The employee knew how to get a hold of her. Miss King and her mother had been recently estranged for over a month. Mariah King discussed with her mother a need for therapy and then left the store on foot. Reportedly, she literally ran away from the place. Kimberly Lapham was worried enough to call in a welfare check, and she did so. Sweet Home Police Department, a guy named Officer Cody McPherson, went to Mariah King's address where she lived with Jared Norman. That's 2241 Nandina Street. Officer McPherson found Jared Norman busy outside. He was working on having a barbecue that day for the people that were at the house. And those people are Jared Norman, Mariah King, Jared Norman's son Barrett, who was 10 years old, Barrett's friend Dylan, who was 12 years old, and Jared Norman's father, David Norman, was also at the residence, although Officer McPherson did not see David Norman because he was inside the house or something like that. Cody McPherson said there was nothing noteworthy about his contact with Jared Norman. Cody McPherson went to the front or main door of the house, and he heard a woman yelling, "Go away," and saying that she was fine. Eventually, Mariah King poked her head out from a shop door, not the main house, but this shop that is attached to it, a workshop of sorts. And she talked to Officer McPherson. She told him, after he asked her, "Are you okay?" She said that she was all right. She said that she was fine, and she asked for him to leave. Officer McPherson noted that she was fuming, that she was possibly angry, and seemed disturbed. He recalled that she probably used profanity during their interchange. He said that Mr. Norman's demeanor was seemingly embarrassed by what was happening, and he seemed like he was feeling down. He did not yell at anyone or use foul language. Mariah King didn't leave that workshop after Officer McPherson drove away. Later that night, Jared Norman discovered that the shop was locked, that she had locked herself inside this building. He eventually got in by finding a key, and he found Mariah King suspended, or partially so, with a rope around her neck. The rope was going through a ceiling eyelet in the shop. I don't know the exact height of the ceiling, but you'll hear about that sooner or later. He immediately called out for his father, who came in. They unwound the rope, and they untied it. Mr. Norman started CPR. Between himself and his father, David, they ended up calling 911. Mr. Norman continued CPR until help arrived from the Sweet Home Fire and Ambulance District.
Need a commercial break. We'll have more from that Oregon courtroom. Plus, Brian Walsh, hour, 13 minutes and counting up in Dedham, Massachusetts. Stay with us. Be right back.
Disappearance of Anna Walsh.
Her husband now charged with her murder.
All eyes on this accused killer. The disappearance of Anna Walsh murder trial. Live coverage today on Court TV.
Tonight on Closing Arguments, Brian Walsh's fate now rests in the hands of 12 jurors. We're live with every development as deliberations get underway.
Closing Arguments with Vinny Politan tonight at 8, 7 Central, only on Court TV.
Investigated this case seems to think that no prints on this cartridge automatically means that gloves were used to insert it. Mr. Norman was interviewed in July and then again in August of 2024 and again in January of 2025. And it wasn't until January of 2025 that he was confronted about this bullet, a bullet that is still in the cartridge. And he was mystified by that and told the police, like she ate it. He didn't understand how that cartridge came to be inside of her body. Furthermore, he admitted that it's the kind of cartridge that goes to his rifle. He said something like that came from my rifle, or that goes with my rifle. And he also said this was a bizarre and weird occurrence that he could not understand. Detective Potter told Mr. Norman that the bullet was inserted after death. The medical examiner, Sean Hurst, disagrees with that and says this is a perimortem injury. It could have been inserted before or after death. Mr. Norman didn't make any incriminating statements ever and was open even about some of the issues that existed in his relationship with Mariah King. That's a summary of some of the things, and again, it's very different from a trial, but that's a summary of some of the things that you will hear testimony about today.
All right, defense attorney laying the groundwork there for the judge in this case. Again, this is a bond hearing of a bizarre. The woman, initially it's a suicide. She's found hanging. The boyfriend's father is there fairly quickly as well when they try to render aid. And then they flip it all up and say this is a murder after they find this unspent cartridge, rifle cartridge, in her abdomen, which was, they believe, got there through the vaginal wall. Philip DeBay is with us. I don't know how that says murder. What's your take on this? It's weird.
Believe it or not, Ted, I have seen this actually many years ago when I worked in the juvenile division in the delinquency courts. We had a young client who had a similar problem. It's a form of self-harm, and it's not, I'm not going to say common. In fact, it's rare. But basically what it is, it's a type of vaginal foreign body insertion, and sometimes they call it DFBI, literally deliberate foreign body insertion. We see it in suicidal people, even in the juvenile community. We see it particularly in people who are emotionally unstable, who have personality disorders. And I think it's sort of making some headway in the forensic world now where they've given it an official name. It's called polyembolocoelomania. And basically what it is, it's a psychiatric, psychosocial disorder that they see in psychosis and in suicidal people. And they've also found it in gynecological literature. And it's a pretty complex patient cohort, but we do see it. It's almost like a form of self-mutilation, and it can be done, you know, pre-mortem and certainly peri-mortem, if you will, but it does not, by any stretch of the imagination, prove a murder.
Yeah, and it sounds as though this case, if and when it goes to trial, will be a battle of experts. And it sounds like some of the literature you have read needs to be brought into this case. But because it's so uncommon, it'll take that, right? It'll take some expert testimony.
Yes, it will. And that is an absolute defense, because they're hanging their hat on that some third person deliberately and intentionally and maybe sadistically inserted that casing into the vaginal cavity. I mean, that's the bottom line. But the truth is, it is a form of self-harm. Again, it goes to that DFBI, the deliberate foreign body insertion. And again, more scientifically, they call it polyembolocoelomania. And it's actually in the literature. And it's really starting to take off, frankly, though, in the gynecological world, where more and more gynecologists are seeing evidence of this. And they're all scratching their heads because they're not trained in psychiatrics and they're not trained in forensics. They're there really to treat the medical aspect.
Well, Philip DeBay, that's why we have you. You have all the information we're after, and and we appreciate you. Enjoy your weekend. We need a break. More from Oregon. And Brian Walsh, what is the jury thinking about? Good golly.
Deliberations room right now, Tamika.
I'll be honest with you. I'm a little surprised. I thought that they would be in and out. The number of issues that were raised with respect to what happened after she died, and the fact that he disposed of the body and did all this, all the searches, things like that. It's actually surprising to me that it's taking this long. However, when there is going to be a guilty, I do think that jurors are conscientious enough to make sure that they go through everything to make sure that they are comfortable with a decision that is going to affect someone's life, and in this particular situation for a very long time.
Tamika, do you think any of them are maybe considering some of the arguments, and they're considering the arguments by the defense, that's what they're supposed to do, but in regard to this idea that he panicked, he didn't know what to do, and so then he chose to do what we've all heard about, chopping up his life and getting rid of the body. Plausible at all? I mean, do you think it's possible they're thinking this?
I think that goes to what I'm saying in terms of making sure they go through every single thing. When they are back there deliberating, they're going to absolutely look at the defense and what he's saying, and then look at that and see, okay, we have this evidence over here, this evidence over here. And in terms of the prosecution, because of course the defense doesn't have to prove anything, has the prosecution laid out their case, and then look at that versus, the plausibility of, I just kind of panicked and I decided to dismember her body and dispose of it over various areas versus, oh my God, my wife has died. Let's go and try to see exactly what happened.
Yeah.
So they're mulling that over because they want to be sure.
I want to be certain, yeah. Well, an hour and 35 minutes. We're going to keep an eye on it. Tamika, thank you so much for your analysis on that. We'll be talking with you throughout the program. But right now, we're going to take you inside that courtroom as soon as there's a verdict. Well, there's not a verdict right now, but as soon as there is, we're going to take you inside that courtroom. Or, of course, if the jurors end up having a question. But as of right now, no questions from there in Dedham, Massachusetts. So for now, why don't we head back to Oregon? This is for the unspent bullet murder case. Gerard Norman, he is accused of killing his girlfriend, Mariah King. Her death was initially ruled a suicide by hanging. Over a year later, the case took a surprising twist when the medical examiner revealed an unspent bullet was found inside King. Let's go back in now for more of the unaired bond hearing. On the stand is an officer. His name is Officer Bryce Barretto, and he is with the Sweet Home Police Department.
Were you on duty on July 18th of 2024?
Yes, I was.
And did you respond to a call at Sweet Home?
Yes.
About what time?
It was approximately 10:50 p.m.
According to my report, it's approximately 22, 54 hours.
And when you arrived, what if anything did you do?
As I arrived, Sweet Home Fire medics, they also arrived on scene at the same time. While they arrived, they went and attempted to perform life-saving measures while I was being guided by my field training officer at the time.
So who was your field training officer?
It was Officer Penninger.
Did you speak to any witnesses while you were there?
I spoke with Barrett Norman and Dylan Mayhew.
And who were those? Were they younger or older?
They were younger.
And where were they?
I believe at the time they were in the living room for my contact.
And in speaking to them, did they see what happened at all?
Can I refer to my report?
Does that help refresh your recollection? Yes. Sure.
When I spoke with Barrett, he told me that there was an argument that happened between Jared and Mariah, but he stated that it was verbal only. When I spoke with Dylan, he told me that during the time of the incident, he was almost falling asleep on the trampoline and he wasn't inside the household at the time.
And did you speak to an older gentleman as well?
Yes, David Norman.
And did he talk to you about what he saw and what he did?
Yeah.
Can you tell us about that?
According to David, he told me that he was cooking dinner at the time when he heard Jared yelling for him, and Barrett as well said that. One moment. That's when they found Mariah on the show.
Did he tell you about anything that he did? If you don't recall.
I don't recall.
Were you wearing body cam?
I was, yeah.
And would that accurately reflect what you observed during that time?
Yes.
Did you eventually go into the shop?
Yeah.
And can you tell us what you saw?
When I went to the shop, I observed Mariah laying on the ground. I have a more detailed depiction of what I've seen in my report.
Will that help you refresh your recollection to review that?
When I went in, I observed Mariah's foot that was laying on the noose, as well as there was a pile of rope that was near her head when she was laying in the shop.
We literally needed to do that. So asked for the medication, we spoke for reading for her, we got an idea, in her backbone, gave her a bunch of medicines. So at this point, there's nothing more we can do. So she asked us if she's passed. Nothing we can do. What could you tell me? Was she hanging on the rope? How did you get her down? What position was she sitting in? Do you have any idea about how long possibly she was there for? When was the last time you talked to her? Was there an officer here doing a wellness check on her? When was the last time I heard her? What went in there? She was on the floor. Her arms reached the ground. Her butt was on the ground. Her neck was in the rope. And the rope was hanging from the hook right above where she was at. She was sitting on the ground. That was on the ground.
We're going to have more of the bond hearing for Jared Norman coming up next. Stay with us. You're watching Court TV, your front row seat to justice. Keep in mind, we have that verdict clock up nearing 2 hours, an hour and 42 minutes there in Massachusetts for that Brian Welsh trial. We'll take you there if there's a question or if there's a verdict. We'll be back.
Tonight on Closing Arguments, Brian Walsh's fate now rests in the hands of 12 jurors. We're live with every development as deliberations get underway.
Closing Arguments with Vinny Politan, tonight at 8/7 Central, only on Court TV.
The Microsoft executive gunned down. Now his ex and her new husband are charged with his murder.
A social media sensation, now a suspected killer.
She wrote a children's book about her husband's death. Now she's accused of killing him.
precise and accurate that stopping in particular. You're looking at is page 3, about the second full paragraph. I don't recall the time when the messages were sent between the two of them. Okay, we have some other witnesses that might be able to address that, but let me ask you this. In those text messages, did Ms. King make any threats of any kind? She made threats of suicide. Were you asking for permission to answer that question by looking over here? No. Okay. Would you please read to the judge that next paragraph of what Jasper Lapham texted back to Ms. King in response to her threats of suicide? In the third paragraph? Yep. Later in the text history, Jasper told Mariah, "It's not like you wanted them anyway. Yeah, I'll just deal with Jared after you leave. Make your choice. I'm the only one trusted, right? You just use me for your own sympathy. See you guys Monday." Only Kim would kill herself for attention. So mother like daughter. I think so. See you guys on Monday. I know who I'm looking for. See you guys on Monday. I know who I'm looking for. You're there or not. After Monday, it will be just you and your little Jared. Cops have been notified, by the way. Did you also locate a few other messages that seemed to have come through her email that were sort of in the same tone and flavor of this argument? That's correct. And did you see in the midst of Ms. King's text back that she texted her brother a photo of her hand holding an item inside of that shop? I don't recall. Perhaps if you want to direct yourself back to that second paragraph on that same page, the last sentence or two of that paragraph. There's a photo of her holding a firearm. Handgun? Correct. In the shop? Correct. Okay. Let's talk about one last topic. So we watched a few clips of your body cam. The second clip began with Mr. Norman coming out on the porch, sort of standing like this with no shirt on, right? Correct. And that's the moment that he is informed that Ms. King had passed, right? Correct. He has a very emotional response to that, right? Correct. How many hours were you at that home that night? I don't recall the exact amount of hours that I was there for. A couple hours at least? At least 3 hours or more. Did Mr. Norman continue to demonstrate a lot of similar emotional behavior throughout the night? Screaming, crying, wailing, all those things? Yeah. Objectively, colleague, those might be all my questions for you. Just one item to clarify. Going back to the brief interview you did with Dylan Mayhew. Feel free to refresh your recollection, but do you recall that one of the things he told you was that he actually saw Miss King in the shop with the noose around her neck and all the screams for help and kind of everybody coming and running? That's correct. Thank you. Those are my questions.
We're going to have more of the bond hearing for Jared Norman next, and a jury is still deliberating in Massachusetts. This is for the Brian Walsh murder trial. You can see nearing 2 hours there for deliberations. Plus, we are waiting for disgraced former Michigan football coach Jerome Moore to walk out of jail after being released on bond. Stay with us. We're coming right back.
Or with her head away from that ligature system, and the upper half of her body was laying on this large coiled rope.
Did you notice anything about Mariah and whether or not did you notice marks on her neck?
I did. So she had obvious ligature furrow to the anterior portion of her neck and I believe it was the right side of her neck, with not much showing on the left side, which again is inconsistent in my training experience with a hanging. She also had multiple bruises to her head. In fact, she had 2 large bumps on her head, as well as bruising. She had bruising on her arms. She had bruising pretty much all over, including some abrasions to her knuckles. To what? Her knuckles. Her knuckles?
So you said it was not, the ligature marks on Mariah's hand were not consistent with a ligature hanging. What did you mean?
That's correct. So usually when somebody is hung, the rope goes up and behind at an angle and not directly back. So hers, again, were the anterior, so the front portion of her neck and the right side. And they went pretty much straight back and not angled up behind the ear. Occasionally you'll get them and you'll see both sides of the rope come up to one side of the neck. But either way, they would usually come up and behind, not directly back.
Did that make sense as to what you were told when you initially arrived?
It was not. My notification when I first received the call was that this was a suicide hanging. And when I got there shortly after that and assessing her body, as well as the injuries to her body, those are my first concerns.
Hello, my name is James Bryant. I'm the father of Ryan's children. It's hard to be here today due to circumstances, but I feel like it can't be unspoken that throughout Jared Norman's and Mariah's whole relationship, he trapped her, he manipulated her. She voiced that to me many times. Me and her co-parented very well together. Our communication was very good until a month before the incident in July 18th. He's threats to actually kill Mariah's family and her back in 2023. CIS investigation was called at that time, and they did do an interview, but it was held at McDonald's instead of the household that this was taking place at. Yeah, so I'm sorry if I seem jumbled. I did not prepare a statement for this, but I feel like he is a threat to the family of Mariah and others, just like Kim said. So I request that you guys the court do not give him bail today.
We're going to have more of the bond hearing for Jared Norman coming up next. Stay with us. You're watching 4TV Live, your front row seat to justice. That verdict clock's still going there in Massachusetts. 2 hours and 11 minutes. If there's a verdict or jury question, we will take you there live. We'll be back. Disappearance of Anna Walsh.
Her husband now charged with her murder.
All eyes on this accused killer. The disappearance of Anna Walsh murder trial. Live coverage today on Court TV.
Tonight on Closing Arguments, Brian Walsh's fate now rests in the hands of 12 jurors. We're live with every development as deliberations get underway.
Closing Arguments with Vinnie Politan tonight at 8, 7 Central, only on Court TV.
Green, and her mom came to go and Green and saw and so had contact with her and then makes the welfare check to Sweet Home PD. So at 9:30, Officer Nickerson is there. He speaks to Ms. King, doesn't note any injuries to her forehead, but does indicate there was a concern for scratches on her neck. At 10:48 is when the 911 call comes in. You have a copy of that in evidence, and that's about an hour and 18 minutes after. So at 9:30, 9:35, Ms. King was alive. There were no injuries to her at that point in time, except for what mom had reported on her neck. EMTs arrived and officers arrived about the same time. When EMTs arrived and officers had their kind of first contact with the EMTs, Officer Barretto's video shows that EMTs are needing a flashlight to see into the shop. So there was no light on in the shop, which should be an important factor for the court to consider, because that shop, it being dark, for Mariah King to hang herself, she would have had to go shut off the lights and walk over and get the noose, put it around her, and do whatever she needed to do to hang herself. Keep in mind that the rope is nicely coiled underneath her head when the lights are on in the office guard, and there's being photos taken. The court has a photo of that. There's information in the court file that the defendant's dad untied a knot while Mr. Norman was holding her up, and tied a knot. Not the noose, didn't take the noose off of her. He untied a knot. That is absolutely impossible. Would not have been able to do that. The noose being around her neck, he could not have fed that through the knot. And because of the very end of the rope is underneath that huge coil of rope, there's no way possible, unless they took the time to rewind it and recoil it before they laid her down to try to do any kind of resuscitation on Mariah King, like they said that they were impossible. Mr. Norman's first conversation is when he was told about what he found, was when the EMTs told him she could not be revived. He indicated to the EMTs he found her on the floor, butt on the ground, and hands reaching the floor. He indicated that she had locked herself in the shed. She may have locked herself in the shed, but he had a key to the shed. He was the only one who had a key to the shed, and he actually was able to go in and lock the shed to check on her. He was the only one with the key. So her locking herself in the shed makes no sense when he's the one who has a key to the shed. He could always go in and lock it. You can tell that her pants were, the bullet in the vagina is the biggest red flag in this whole case. Actually, it's not even in her vagina anymore. It was pushed through her vaginal wall and it was found floating within her abdominal cavity. Dr. Hurst even indicated in his grand jury testimony that it would take a great deal of force and it would cause a great deal of pain for anybody to do that to themselves. Now, whether it's perimortem or postmortem, in order to, and for a female to do this to herself, you have to think about this. She would have to exert an extreme amount of pressure to push it through her vaginal wall. And while she's in a great deal of pain, she would have to walk herself over, make sure she's hanging herself like almost instantly for that to even make any sense. Any sense. Not only that, she doesn't have, she has some other suspicious marks, as Dr. Hurst indicated. She has these knots on her head and her forehead that were not visible to Officer McPherson. Mom didn't indicate in the call for welfare check about those. She only indicated there were scratches on her neck. Kenneth Roskin, his duties are defined under ORS 146-085 to 146-107. He indicated to the court that there was not a bite in the rope, which means there was nothing to stop the rope. You don't have to be a rocket scientist and figure out that you need to have something that'll stop that rope, so you don't end up on your butt and your hands on the ground so that you are strangling yourself. That's just a common sense kind of thing. He also testified there was no way to get somebody suspended. He also indicated that it was not consistent with a hanging suicide based on his training and experience in the many suicides that he has attended. Multiple bruises, and he also testified that the lividity goes to the lowest points, fingers, toes, and hanging. He found it on her back. His job is to respond to death scenes and explain, examine the body, examine the scenes for any potential evidence that would help in determining cause and manner of death. Yes, he cannot certify cause and manner, which means he can't put it on a death certificate. He can't do a death certificate, but he can investigate and come up with his own determinations to give to the ME about the cause and manner of death. That is his job. The injury to the back of her head was not noticed when he did his initial examination. He didn't find any blood on the ground, and he didn't have any blood on his gloves as he testified. There's some, Mr. Roskin and Detective Potter both indicated that they did have a conference with Dr. Hurst, and Dr. Hurst did indicate to them that he believed it was post-mortem. And now he's saying perimortem in his final report, well, in his grand jury testimony. So there is that potential. Detective Potter interviewed and reviewed other officer reports, and there was at least a couple days before this, she was afraid of the defendant. She had been hiding underneath the children's bed because she was afraid. She had made that comment to Dawn Cunningham. While she was at Going Green earlier on that day, she told Jeanette Taylor that things had got physical between the two of them. McPherson responded to the welfare check, and it was for domestic violence, not because she was suicidal. And McPherson testified today that he had not responded to a call at that residence for anything but a dispute between neighbors. So there had not, at least with McPherson's knowledge, any kind of a suicide attempt prior to that. And keep in mind that the manner of death is undetermined. Dr. Hurst didn't say it was suicide, and he did not say it was homicide, but he most definitely did not say it was suicide. He did say that there were concerning features, the TPI, the conjunctiva, face laceration, and the face laceration to the scalp, and the intact rifle cartridge inserted through the vaginal mucosa. He said at grand jury that the petechiae is more common in cases of strangulation and not hanging suicide. I would ask that the court find that we have shown that the presumption is strong and deny that for the defendant.
Thank you, Judge. Several of the things that the state told you in their closing argument today, I just don't understand. And so I'm not going to try to refute those things. Instead, I'm going to stick with the plan and tell you the things that we think are important for this bail hearing. But it does bother me that the state says things like it's not possible to untie a knot in a rope in a certain way, or that it's not possible to lock the door to the shed from the inside because Mr. Norman has a key. Those things just don't make sense. And I don't know why those are presented to you in that fashion. The state's right about the statute, though. 135240 says bail's to be denied unless the proof is evident or the presumption is strong that the defendant is guilty. And these are findings which are hard, if not impossible, to make on the record that you have in this case.
Listening to defense counsel make his arguments there during this bail hearing, why don't we bring in trial attorney Tamika Grabowski to talk about and review what we just listened to. We've been playing Tamika, this bond hearing from Oregon. We listened to the prosecutor. Now defense is getting up there saying, I don't understand a lot of the things that she was saying, not important, not relevant here. What's your take on this?
Well, I kind of agree with the first thing that he said in terms of the absolutes that the prosecutor was speaking in terms of. I think you have to be very mindful of speaking absolutes, because if that's what you're counting on, that it is absolutely true, and something comes up, something is demonstrated, an expert testifies to something that is contrary to that, then that kind of knocks your case, kind of knocks your credibility in bringing your case. As far as the litany of items that she went through as making this just clad iron, I don't think that that's necessarily the case. Initially, I could not see why they thought this was so strong, but as she went through, there are some things they're going to have to flesh out, like the turmoil in their relationship, and then the force that it took to get the bullet into the vaginal wall. So I think there are some things there.
Yeah, definitely still a lot of questions here in this one. Tamika, thank you so much for your excellent insight. Appreciate you joining us this hour. And coming up, we're going to have more of that bond hearing for Jared Norman. Plus, you can see that verdict clock. The jury still deliberating in the Brian Walsh murder trial. Almost 2 hours and 30 minutes. We'll be back.
That term is used throughout. So what is it that term is used in other numbers? So is it something about that particular photo that is problematic with that description?
Oh, I just was,
I mean,
I just don't like it, but
I know you don't like it, but I'm trying to distinguish between, I think there was one witness who used that term butcher paper as opposed to bench paper. And I don't think it was the witness that was associated with that. This is just the old-fashioned terminology that people often use to describe that paper. I think I used it at the side of the bench one time, not in front of the jury, but just with you. But I think that is there's a more neutral characterization that would be appropriate and more in line with what the witnesses actually testified to. But as to the other language in 189, it seems to me that that's what the witness testified to, right?
Yes, Your Honor.
Anybody, let's all take a moment to look through the list right now and see if there's anything. I'm going to do that right now. The answer to their question is 97, by the way.
Yes.
Let me just take the time to look through these, and you do the same.
blood clots in.
All right, so I'm going to write back to the jurors and I will give them the name of, or the number of the photo, which is, I'll answer it as exhibit number 97. And here's an exhibit list to assist you.
Thank you, Your Honor.
Here you go, Madam Clerk. If you want to look at it, you're welcome to. It's pretty straightforward. Thank you.
Either the intentional killing or rather a heat of passion killing.
You know, I'm not sure why the jury is fixated on this particular piece
Back Court TV Live, I'm Judge Ashley Wilcott.
And I'm Kelly Craft. Thank you so much for being with us on this Friday.
We are in Dedham, Massachusetts, where the murder trial against Brian Walsh is coming to a close. The jury has now been deliberating for approximately 3 hours and 25 minutes. Kelly, a little longer than I might have expected.
Me too. So Walsh stands accused of killing and dismembering his wife, Anna. This all took place New Year's Day back in 2023. And he told the court just earlier this week that he would not be testifying in his own defense.
As an initial matter, does the defense still intend to call Mr. Walsh today?
We do not.
You do not? All right. Does that move every issue that I researched last night?
I apologize, Judge.
No, I just want to make sure that the 5 issues that you raised and the issue with regard to the plea are no longer on the table. All right. I will conduct a colloquy with the defendant then now, and my intention is the defense intend to call any other witnesses.
You're not.
Have you made a decision about whether you wish to testify at this trial?
Yes, I have.
And what is your decision?
I will not testify.
Not testifying in this case. Now, a reminder, he had already, prior to the trial, pled guilty, as a surprise to most, of misleading the police and also unlawful concealment of a body. While we wait for the verdict to come in, Court TV's own Matt Johnson has a closer look at the timeline of this case.
No comment from Brian Walsh after he was charged with the murder of his wife, Anna Walsh, the missing Massachusetts mother of 3 young boys. And while he's not talking, prosecutors are piecing together a timeline of what they say he was doing in the days after her disappearance. Prosecutors say that Anna Walsh was last seen here at her Cohasset home on New Year's Day. Anna was last seen at home between 4 and 5 a.m. by a family member. Walsh told police that he had slept in that morning, but prosecutors say that he was actually awake and searching disturbing topics on his son's iPad.
At 4:55 a.m. on January 1st, he searched how long before a body starts to smell. At 4:58 a.m., how to stop a body from decomposing. At 5:20 a.m., he searched how to mount the body. At 5:47 a.m., 10 ways to dispose of a dead body if you really need to. At 6:25 a.m. on the 1st, how long for someone to be missing to inherit. At 6:34 a.m. on the 1st, can you throw away body parts?
The very next day, more Google searches.
There were also more Google searches on January 2nd. At 12:45 p.m., caps lock best tool to dismember. At 1:10 p.m., can you be charged with murder without a body? At 1:14 p.m., can you identify a body with broken teeth?
Prosecutors say that on January 2nd, Walsh came here to this Home Depot store, located in Rockland, Massachusetts, 9 miles from his house. He spent $450 on cleaning supplies.
Items included cleaning products, mops, brushes, tape, towel, a tie-back suit with boot covers, buckets, goggles, baking soda, a hatchet.
Investigators say that he also visited a home goods store in Norwell, where he purchased 3 area rugs. Just down the road, Walsh was caught on camera, pacing back and forth in this juice bar, where he ordered a smoothie for his son. Once at home, investigators say Anna's phone was turned off for good after 2 days of no outgoing calls. On January 3rd, prosecutors say Walsh drove to an apartment complex in Abington, 16 miles from his home, where they say surveillance video shows him hoisting a heavy garbage bag into a dumpster. At 4:48 p.m., prosecutors say Walsh drove to a second apartment complex in Abington. And at 5:10 p.m., investigators say he threw items away into a dumpster in Brockton. That's located an additional 10 miles away from his home.
On January 3rd, that same day, at 1:02 p.m., he did some more Google searches. What happens to hair on a dead body? At 1:13 p.m., what is the rate of decomposition of a body found in a plastic bag compared to on a surface in the woods? At 1:20 p.m., can baking soda mask or make a body smell good?
On January 4th, Anna was reported missing by Washington, D.C. coworkers after she didn't show up for work. Meanwhile, investigators say Brian was busy buying more supplies. On January 4th, prosecutors say that he came back to this home goods store. He also went to the TJ Maxx next door. On this day, he purchased towels, a bath mat, and some men's clothing. At 4:15 p.m., Walsh went to Lowe's and purchased squeegees and a trash can. Later that day, when police arrived at his house to do a welfare check on Anna, they observed the back seats of his Volvo down and a plastic liner in the back.
Chemists later analyzed the car and there was present blood in the car.
On January 5th, cell data shows Walsh's phone was in Swampscott, where his mom lives, located 40 miles away from his home. Investigators say that the phone traveled to the back of the building, where a dumpster was located. Then on January 6th and 7th, police searched the Walsh property in Cohasset. Prosecutors collected a lot of evidence in the basement of this home, including DNA blood evidence and 2 knives. On January 8th, Walsh was arrested for misleading police in his wife's missing person investigation. The next day, he was arraigned and pled not guilty. Then on January 17th, prosecutors announced that he would be charged with her murder. The next day, he was back in court.
The defendant is now before the court charged with murder of his wife, Anna Walsh, as well as disappearing of a body.
As we wait for any more movement inside that Dedham, Massachusetts courtroom, we do want to welcome in our guest, criminal defense attorney Joanna Nieves. Joanna, thank you so much for being with us on this Friday. We appreciate you joining us as we await a verdict or some more movement in this case we're watching in Massachusetts. What do you think the jurors are deliberating about?
I definitely think it's coming down to one, whether or not there was an actual homicide that was committed in, this argument about the sudden death and whether they think that that's a believable and credible argument made by the defense. And then was there like an intent to kill in a premeditated manner for them to get to the first degree conviction on this, or was much of this a kind of heat of the passion, implied malice in situation where they land on a second degree murder? So I think that they're actually having some conversations and deliberating over the evidence or the lack thereof to make their final decision. I do think they're going to come back with a conviction, though.
So when they came out with a question, we learned the jury question was about an exhibit number 97 by the Commonwealth, and it specifically was about some pictures and a plastic container with blood clots and substances. Here we can see a picture of that. It may have been about that. It could have been about Anna lying on the rug. But when you look at these specifically, do you think this might be something that could give them evidence of what you just pointed out, either the intentional killing or rather a heat of passion killing?
I'm not sure why the jury is fixated on this particular piece of evidence. I actually think the more compelling evidence for them to consider are the internet searches. I don't know that by kind of assessing the blood in this case is going to really highlight much for them, because he has already admitted to disposing of the body. So much of that blood could be argued that it came from the actual dismemberment portion of the case. And I don't think that they're going to reach some sort of like epiphany or conclusion about how she died versus the fact that she did, and was he the one to do it? And I think that the searches really give some insight about where his mind was at, and that's what they should consider.
You wonder if just one of those jurors in there is fixated on this and saying, well, let's just go ahead. Let's take a look at that. Let's examine that a little more closely to try to prove their point to the rest of the jurors when they have that robust debate inside the deliberations room. I mean, who knows? But you mentioned those Google searches. I mean, these terrible Google searches. Defense counsel addressed that, saying that they were unthinkable. And also, talking about the fact that he lied. He told investigators initially that she went off to D.C., that she had an emergency at work, and that's where she was. That's what he told investigators. So there are a slew of lies that he told investigators here after she was gone.
Yeah, and that definitely speaks to consciousness of guilt. And the defense is going to say, well, he was trying to cover something up. I mean, he got rid of the body. But when we talk about those internet searches, what I would be expecting if I'm a juror is, okay, your wife suddenly dies. Why aren't you Googling, why would somebody randomly die? My perfectly healthy wife is dead. Should I call the police? What do I do in a situation if I walked in on a dead body? Rather, instead, he's like, how do I dismember a body and what's the best tool to use? And he's Googling murder. It just does not look good for him. And I think circumstantially, they're going to piece together that he actually did commit a crime of murder rather than stumble upon his wife unexpectedly dead.
And one of the things is the defense said in their opening that you were going to hear evidence that this was sudden death, but the defense didn't put up any witnesses. I was looking specifically for a witness, but Michael Ayala and I were talking about it, and he said, but